Judge here.
Give me 1 second, please. We got a little.
Let's come down. That's fine. That's fine. A bit bigger. Look back off of it. Go back to that where the squares were. Go to the bottom left.
Here,
Yeah, try that. No.
he's coming.
Yeah, it's cool.
See, I don't know what's going on. I see my ugly mug. This, what? I don't know what happened.
You don't have, he needs that.
I need that.
Okay.
Linda invited me to join, which I did.
Right. Is it a gallery or something? Let's just turn this. Please touch. That should have turned you off. You may have to restart. Yeah, it's not. Hide self-view should have turned off. I think we would need to restart this.
Linda had asked me to join, which I just did. And then when I clicked on video.
I mean, we could have it like that.
No,
you still show up on camera. Oh, you need to see them.
I want to see.
Yeah. I think we would need to reboot Zoom. Because the view right here, hitting view, hide self view, and show non-video participants and gallery should show everybody. Wait, participants one. So she hasn't added you. Or who's host? Did you add it? Yeah, he's set up like he always does every day.
Linda did.
I don't know what Linda's saying.
Joining.
I didn't do anything.
No, it said join. It asked me to join, and I don't know why, but I clicked on it. It said it came from you. I'm not blaming anybody, believe me.
Oh, you were in a breakout room. There you go.
Oh, I was in a breakout room. Okay.
Oh, right, Phillips.
Sorry, everybody. Give me 1 second here. What is going on? Where's my picture? There I am. Okay. All right. LVNV versus Judith M. Weaver, 2502129. Ms. Weaver, are you out there?
Yes,
Okay. Your name
Judith Weaver.
and Mr. Barta?
Good morning, Your Honor. Suzanne Barta, P65425 on behalf of the plaintiff.
Did the two of you talk? Have any discussions on this?
Your Honor, I apologize because I have a feed in front of you this morning. I'm just pulling up this file. And the first thing that I see is that this has already been resolved and a consent judgment was sent to Ms. Weaver on September 2nd, 2025. I don't know if she has received that yet or if she needs us to send her another one, but it has been resolved.
Do you have that document, ma'am?
No, I do not.
Did you email it or mail it by UPS?
We mailed it to 23539 West Dittner Drive, Rockwood, Michigan, 48173, but I can email it to her if she wants to give me her email address.
Sure. Jazz, J-A-Z, the number 1, Judy, at Comcast.net.
That was Jazz, J-A-Z, the number 1, Judy, J-U-D-Y at Comcast.net.
That's correct.
Perfect. We will send that to you hopefully by today or tomorrow. So, Your Honor, I don't know if you wish to adjourn the matter out 30 days to just have it on the books or just notate the file that the consent is coming.
Let me just make a note. All right, let's just adjourn it out a couple of weeks. Adjourn the pretrial out. Linda, please give me like 2 weeks out.
2 weeks?
Yes.
Okay. How about October 6th at 9:30?
At 9:30 in the morning. So ma'am, as soon as you get that, if you send that back, you should have the order back, whether it was a conditional dismissal order or consent judgment, and then you won't have to appear. But make sure you receive a document back signed by me before you decide not to appear, okay?
Okay, thank you.
And Your
Any
Honor,
questions, ma'am?
one last thing, because her first payment was due on September 20th. I just wanted to ask, have you made that payment or are you planning on making that payment?
I have not made that payment yet.
Okay, I would make that payment as soon as possible.
Okay,
Okay.
all right.
All right. Wish you well. Good luck. Thank you.
Thank
Thank
you.
you, Your Honor.
Portfolio Recovery versus Rebecca Sislo, 2502406.
Good morning, Your Honor. This is Barta P65425 on behalf of Portfolio Recovery Associates.
Ma'am, your name? You have to unmute. Bottom left-hand corner of your screen. You have to unmute.
There we go. Rebecca Sislo.
All right. Any resolution on this one, Mr. Barta?
Your Honor, Ms. Sislo has a debt consolidation firm and they have been reaching out to us even as recently as 2 days ago. There was conversation. I think this is going to get resolved. It either has been resolved or it's going to be resolved in the next 24 hours. So I would respectfully request another adjourn date here and hopefully we can get the resolution documents to you. The only thing, Your Honor, is with 14-day adjournment, I'm always scared with a debt consolidation firm that we can't turn around those docs fast enough.
Well, I'm going to adjourn it one last time. If it's not adjourned, I'll just set it for trial. I mean, they move a lot slower than any lawyer for sure. Give me 4 weeks on this one, Linda.
Okay, October 20th at 9:30.
October 20th at 9:30. And if it doesn't resolve, then I'll just set it for trial. Okay. Ma'am, you should call your debt consolidation company and ask them to move this along if you would, please. Okay.
I will. Thank you.
Have a great day. Thank you.
Thank
Your
you.
Honor.
Performance Equity versus David Fry, 2502728.
Good morning, James Shirley for plaintiff.
Angela Jackson for Performance Equity Partners.
Your name, sir?
Fry.
Okay, so nobody appeared July 29th. I adjourned it, and then everybody was here August 27. I granted the plaintiff's motion for possession pending final judgment. Where are we with this now, counsel? Have you talked to Mr. Fry?
No, the first hearing was adjourned for lack of service, Your Honor, and reset for August 26th. Ms. Jackson and I appeared at that hearing, and this court entered a judgment of possession by default. It's a claim and delivery case involving a mobile home. Mr. Fry has now filed a motion to set aside the default, and it's his motion.
Oh, hang on. I got a slew of them over here. Okay. Why weren't you here?
Because my original court document was scribbled off where my date was and wrote above it the 28th,
Let me see.
clearly an 8th. You have the original copy. I turned it in, but I have a copy of it right here.
Your Honor, you should have a
Yeah.
copy of that service.
I do. Slow down. Just slow down. Just slow down. It doesn't look very clear on my copy. Somebody changed the dates by writing on it, it still looks like the 26th to me.
I mean, everybody, I've zoomed in, look, there's a circle on the top of it. It clearly looked like an 8 to me. And I was here on the 28th that morning and they said that it was 2 days ago.
Can you verify that he came in, Linda?
Yeah,
On the
yes, he did. Yes, he did.
All right. Well, counsel, under the circumstances, I'm going to set aside the default.
Your Honor, Mr. Fry has to show two things here. Good cause.
I know, but you know what? There was not enough. There's good cause. I'm looking at this. Somebody could have mistaken it for the 28th. He came in the 28th, and I'm not gonna. I don't even need to get to the issue of meritorious defense. As far as I'm concerned, there's still sufficient grounds for him to have looked at this and said, "I'm supposed to be there the 26th. I'm not about to penalize him for not doing that." So the default is set aside. Why you guys want to go into a breakout room and talk about this?
Your Honor, this has been an ongoing problem. Mr. Fry, as of last Thursday, is 156 days late. The last payment he made was the one that this court ordered him to make back on April 7, and there's been nothing since then.
And that's because he asked you if he can make it and you said yes. And we went through a bunch of commotion at that time too.
Well, I'm going to go ahead and set aside the judgment by default, but I'm going to let him argue his motion now. Do you understand that?
Yeah.
I mean, you got to make your payments.
I absolutely will.
Well, you haven't. You got it all now? Do you have it all now?
I do. The only issue.
Hang on, slow down. Now, don't start fudging on me, please. There's no issue. You either have it or you don't have it. Slow down. Don't before you say a word. How much is owed, Mr. Sherrill?
$8,336.10.
You have that money?
Not that much.
Well, how much do you have?
I have about 4,000 I could give them.
Well, that's not enough.
Came from, I got like $2,000 in legal fees on this paper, all wrote with dates, except
Slow down. Slow down.
only one
Slow down. Wait. What do you mean you got $2,000 in legal fees?
on this paper right here.
I don't know what paper you're talking about. I don't.
Court papers that I have. All of them are.
You know what he's talking about, Mr. Sherrill?
He could be talking about attachment 3 to the complaint, which is a loan summary.
Thank you.
That was back from June.
I gotta have that, Lisa. Linda, I gotta have that paper.
What is it?
Loan snapshot. I think it's attachment 3.
It's a breakdown of all his legal fees with Performance Equity Partners. Because we were in court the last time with you, Judge, with the same scenario. And back then, he was supposed to have a judgment and paid then, and now we're waiting for him to pay now.
Yeah, you know, you can't come in here with half of it.
No way.
Okay, what? You're including legal fees that you're entitled to by contract, right, Mr. Sherrill?
That's correct. Legal
Well,
fees, accrued
You
interest,
gotta pay them.
unpaid escrow.
I mean, you paid in April, they tell me, is that true? April 7th, I believe? And haven't made a payment since?
Uh-uh.
Supposed to bring me current, and almost all
Well,
the
but
these charges are before that date.
I need that document, Linda, please.
I'm working on it, Your Honor.
Okay, take your time.
I-
What? Go ahead, I'm gonna listen. Go
Okay,
ahead.
so I've tried to call the defendant several times after we were in court with you the last time, Judge, and he doesn't answer his calls. So I reach out to the park that he rents from, and now he's been in court with the park more than 16 times. Now we're in court with you. This is going on our third time because first it was going to be a judgment and you let him pay. Now it's like the date, so we came back and we're here now. And this is going to be an ongoing problem with him consistently if we keep letting him get current and then we'll go back to
Don't
this.
disagree. You don't have to. Let your lawyer argue this, though. Mr. Sherrill, tell me what you want right now. What are you asking me to do? Re-enter the default?
Yes, please. with a 28-day period in which to serve it.
Do you have any?
The only thing I can do.
Correct me if I'm wrong. Did I just not last time grant the? I really want to look at that. I just granted, my only note said I granted your motion for possession pending final judgment last time.
Okay, last time,
I'm talking August 26th.
right, that was a previous hearing in this case, correct? That's
Well,
what he's
when,
trying.
no,
Yeah,
I get, but you're saying I entered a default.
Yeah, in this case.
There's a
we did.
difference.
Yeah. Well, I had sent the court a default back on April 26th, and he immediately filed his motion. The previous case, the court ordered him to come current with it, which he did that day, and then I dismissed it with albeit with a caution that we'd probably be back, and here we are.
Okay, but as it stands now, I never entered the default that you presented previously was set aside, correct?
I don't have a copy of it, Your Honor. That's probably what happened.
Can you verify that or not, Linda?
Your Honor, I have Gina run. She should be there any second with
Well,
your
I have
papers.
this loan snapshot, but can you verify that I previously set aside the default, or at least he presented an order, proposed order setting aside default, and that I signed it?
I'm looking right now.
I mean, it seems to me that the only appropriate thing right now, Mr. Sherrill, is for me to grant your motion for possession pending final judgment.
I agree.
Okay, so you're not
Well-
asking me to,
That looks like you signed that on August 26th.
right, because that's what I ordered when the defendant
Okay.
failed to appear. Sir,
I don't see any other judgments in here.
but there was one back in April that was entered, and I set aside or he at least filed the default, and I then set it aside on when he submitted the order, correct? I know, I'm throwing a lot at you. Life was a lot easier, Mr. Sherrill, when we used to have files.
Yeah. Would you like the previous case number?
No, I don't think I need that, do I? I mean, this is an entirely different case from the one you're referring to, right?
It is.
Okay. So you need to set aside the order granting motion for possession pending final judgment. And then indicate, and I'm going to give you a hearing right now. And you're going to tell me why I shouldn't enter the order for possession pending final judgment. You got to pay.
I do. I just don't see how 6 payments is $8,000. That doesn't make any sense. I mean, that's why my issue with paying it was all these fees.
Well, you're in default.
They're all.
I mean, you've defaulted on these payment terms, right? Good. So what are your legal fees? 407, how much per hour, counsel?
$275.
275?
Correct.
That's kind of cheap for a man of your stature.
Well, there you go.
I mean, it is. So I'm going to grant so I want you to craft another order. I hate to put you through this, but he was entitled to a hearing. So you say this having come on defendant's motion to set aside default, specifically with respect to the order granting possession pending final judgment on whatever date that I entered it. And oral argument having been heard and the court having found, and if I'm going too fast, I know you're a smart guy. You can go ahead and paraphrase this. You don't have to do this word for word. Court having found there was good cause for defendant's failure to appear on August 26 of 25. The order granting possession pending final judgment is set aside and a hearing granted. And then you can go on and say, it is further ordered that following a hearing, the court has decided, the court is granting plaintiff's motion for possession pending final judgment. And you can include all the other paragraphs that have to do with order granting possession final judgment.
Very good. And there's
Okay.
no request for money judgment here. We just simply want possession.
Well, remember, you're only getting possession
Right.
pending final judgment.
Right. If this order is then served, I can simply dismiss this case once we have possession.
Well, I mean, technically, I think you need a judgment.
Yeah.
Okay, you need a judgment before you can take the property pending final judgment, but you can't, you got to have a judgment awarding it ultimately. So I would not recommend you go about it that route.
All right.
Just let me make one note here. And maybe you two can talk and compare figures. But you're clearly in arrears, whether it's 4,000 or 8,000.
100%.
Okay, hang on one second. Let me just make some notes.
I say so.
Not yet, please. There's nothing else to say. I mean, there's really nothing else to say. I don't know what you want to say. You're gonna have to talk to him, see if you can resolve it. You can't just let these things go like this, sir. I mean, I helped you on April 7th. I went out of my way for you and you made one payment and this is September. That's 9 months later, 5 months later, rather. Okay, I would suggest you talk to Mr. Sherrill, see if you can work something out, but do you work?
Sir,
Where do you work?
plumber. Yeah.
I don't know what else to tell you. I'm sorry. Good luck to you. Thank you. Send your order over, Mr. Sherrill, please. Thank you.
Will do. Thank you.
Philip, let me take Mr. Do we have Mr. Mayer's case at 8:30? This is Concord versus Sophia Norris, 2503110.
Good morning, Your Honor. Ralph Mayers, P23815, appearing on behalf of the plaintiff. And I have good news for the court. No drama on this case, Your Honor. We're withdrawing our motion for issuance of a writ. As of Friday, I talked to the office and the defendant became current.
Okay, would you prepare an order for me that indicates again, the defendant filed a motion to stay the issuance of the writ, and the parties have resolved the matter. It is hereby ordered that the parties agree that payment has been made and that the case be dismissed without prejudice.
Very well, Your Honor. I'll submit that order.
Is that all right? Or you want me to do something else?
No, that'll be fine, Your Honor. I'll submit that today.
Nice to see you, Mr.
Wilson.
Just that will be resolved as soon as it's been completed.
Thank you. Nicholas Faria.
He's here. Cheaper. Let's go over.
Let's see what Mel is all about here. Mel, this is very slow. Chooses his fights wisely. See if I can see where the weakness is. It looks like there was a blood draw.
There was, yes, sure.
What was the?
I don't remember off the top of my head.
A 1-1, 2 hours later.
That sounds about right.
Okay.
State is not ready as I am doing punishment in that continuous case.
Yeah.
And I will be gone several days this week for my new employment.
Go ahead, Lee. We're stuck holding the bag.
Sorry.
I understand. That may need to be reset.
Do we need to come back at 1?
No.
Thank you.
Thank you, Your Honor.
Please get a resetting mail. Thank you. Sterling Booker.
Judge, as of right now, she's not here. I looked outside for her, but I hope she's coming.
All right, 24 CR 2032 is called the state of Texas versus Sterling Booker. No answer in the courtroom. I asked the bailiff to call into the hall, please, for Sterling Booker. Sterling Booker.
Sterling Booker. Normally she's on here. I don't know what happened, Judge. Normally I don't know.
That helps me a lot.
No response, John?
I don't know what happened. No response to that name called in the courtroom. No response to the name Sterling Booker called in the hallway. Defendant has failed to appear for a trial docket. A warrant shall be issued for. It's a female, I believe, right? Or male? Male or female?
She's a female.
She is a female.
She is female.
Okay. Warrant is issued for her arrest. Bond
Currently 15,000.
is revoked. Warrant issued for her arrest. No bond at this time. This is trial document. Okay. Arias Wilson.
Judge, she's here.
Sure.
You have appointed me to represent her, but she's hired Mr. Kimbler. Come on up. She's hired Mr. Kimbler on for the trial docket, so I guess he's going to try the case.
Is that right, man?
Yes, sir.
Okay, that's fine. Great. Okay, we got you here, and your attorney though should be here, but he's not. And we'll revoke his bond and something long overdue, I think. I'm sure he'll handle in shortly.
I have a letter of representation. So
When did you hire him?
I had no Friday anyway.
Hello. Kind of waited to the last minute there, huh?
Well, yeah, but I've been going through stuff. I have to get my
Okay.
kid ready for school and stuff.
Okay,
So
yeah.
I'm struggling.
Yeah, he needs to get something in writing into the record. He did not do that yet. But until then, Mr. Adams is your attorney, but we're going to work with you so that the person you intend and want to represent you is placed. And that means we'll probably have to reset this case. Okay, but just stay close by.
Yes.
Ryan Manuel.
Wait my wife to give you.
Ryan Manuel, Joe Vasquez.
Actually, please, Your Honor.
Okay. Let me take care of some other things. I'm going to jump ahead. Mr. Turk, Monica Vincent. I know we're a little ahead of this, but we can move some items if you're ready to. It says definitive plea to 2 cases. Yes, sir. And hold on, before we do this. Mr. Walker, on Jonathan Garcia, what do you want to do?
Judge,
We're ahead of the time, but are you ready to move forward?
He should be here. It's an LA email.
What do you want to do?
I was plotting actually with you. Just please.
Oh.
And she's judge. And she was in every, I've seen a case with how he said.
Your attorney, and there is a motion that has been filed. Mr. Garcia standing by. Let me put that. Stand by. Could you have Jonathan Garcia over there, please? That's on the 9:30. There's a motion to withdraw that was filed August 13th by Mr. Walker, your attorney, and good cause exists according to the motion. Apparently, there are issues concerning the contract that had been entered into, and I think it's a payment issue, it looks like. Well, the attorneys have to get paid unless you're indigent. And if you were indigent, an attorney can be assigned and appointed to represent you if you were unable to pay. But what has happened is this case is languishing too long and it needs to move forward. And the attorneys, the contract that y'all get together with, I don't really get involved in that except when motions to withdraw are filed. And the court is inclined to, with good cause, always grant a motion that is filed, and a motion to withdraw with a failure to pay. The court considers those seriously and will tend to grant the movement, the person who filed the motion, your attorney, the relief he's asking for, which means you're going to have to try to hire somebody else if you can. You understand where we sit here?
Yes, sir.
Do you understand the situation? You know more than anybody how much you've paid in this. Would you say you have failed to pay as agreed? That's what the motion says. I know Mr. Walker to be an honest man.
Yeah, the thing is, when my wife stopped paying.
Okay. Well, I mean, and money, we all have from time to time money issues, but there are ways of dealing with this. You're not going to be without representation. You just may not be represented by the man you hired if you're unable to pay it. Well, do you agree you're unable to pay him right now?
Yes.
Now, are you able to pay him?
No,
You're not able to. Okay. I'm going to find good cause to grant the motion to withdraw. Mr. Walker will be released by order of the court. And then what we'll do is work on getting you somebody who's a competent lawyer to represent you until unless such time you can pay and hire your lawyer of your choice. Do you understand?
Mm-hmm.
Well, we're going to get you somebody to take care who's competent.
Judge, just again, there's lots of witness statements. Every witness wrote their statement in Spanish, so Spanish speaker may be.
Good idea.
There's what is next? Just all this, it's what I want to ask if you'll come. That's what I just asked. Sometimes I get when it's straight.
And we're going to get an attorney appointed. I've got to make some calls. We'll get an attorney appointed to represent you very soon. I want please to review this on Wednesday, bring it back on Wednesday. Thank you. All right. This day, Mr. Walker is released from representation. All right. Yes, sir.
Yes.
Who do we have off the docket? Any, please, ready?
Monica Vincent is ready.
Monica Vincent? Monica Vincent, please. Mr. Firth. 2 cases. Monica Vincent?
She's in the back.
In the back. Oh, back there. In the other back. Monica Vincent.
You saw this all when we changed, basically. Did you say I was on the too? Did you simply sign?
Yes, yes, it's already in Judge Keys. I'm fine, buddy. I don't know what mom said.
Y'all try that all week.
I know, I asked her that, but she was like, be the.
You're Monica Vincent?
Yes, sir. Come in front of me, please.
Almost.
Says raise the right hand.
She pleading to both or one?
You're gonna do something about it. Ink up your right thumb print. Okay, place it flat right there. Get up one more time. Okay. Place it flat right here.
Yeah.
All right, this is my note. Thank you.
More, please. 2 cases are called 24 CR 2342 and 25 CR 1200, both styled the state of Texas versus Monica Vincent, also known as Monica Lynn Vincent. I have some addresses here. I have 6400 32nd. It says 32nd 64th Street. That can't be right. I grew up in Groves and there's no such thing as that. And then I've got 1199 Dolly Drive.
That was my house, but I had to let it go.
You have to, okay, the most recent address is going to be 6400
Yes.
32nd.
Yes, sir.
Okay.
Y'all, did you get it?
You try that soon.
I tried refreshing. It's not coming up, so. Remember that? Just work. I have this thing and boom.
All right, in 24 CR, and by the way, does the defendant waive formal readings of these indictments, can we proceed in summary? Mr. Turkis, her attorney.
Yes, Judge.
In summary, 24 CR 2342 alleges that on or about October 15th, 2024 in Jefferson County, Texas, you committed the third degree felony of evading arrest or detention with a motor vehicle. You understand what you're charged with?
To go on count one on both these, Judge.
Just count paragraph one.
Paragraph one is fine.
And 25 CR 1200 in summary, it alleges that on or about July 8th, 2024, in Jefferson County, Texas, you committed the second degree felony of illegal possession of a controlled substance, namely phencyclidine, PCP.
Yeah.
Do you understand what you're charged with in these two cases?
Yes, Your Honor.
2342. It's a third degree felony, which means you are facing no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 to be assessed. The agreement's been reached in that case where you would be pleading guilty. And sentenced to 5 years in prison to run concurrently with the next case, 25 CR 1200, you're going to be dealing with here. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
We're going to hold that one in abeyance for just a moment. We're going to go to 25 CR 1200. This case of illegal possession of phencyclidine, if convicted, this is a second degree felony, which means you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand it?
Yes, sir.
An agreement's been reached as well. In this case, you would be pleading guilty, sentenced to 5 years in prison to run concurrently with the other case. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 in each case. Did you sign those documents, understand them, discuss them with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
Okay.
Without objection, it's submitted. In each of these cases, State's Exhibit 1 state that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've written you were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record in each of these cases. Pre-sentence reports away here.
Yes, Judge.
I will follow these agreements and find you are indeed mentally competent to enter these guilty pleas. They are freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt in each of these cases. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years confinement in each case. These sentences shall run concurrently. Do you understand what has happened today, ma'am?
Yes, sir.
So, what are you going to do with your life
I plan
from here on?
Yes, sir. I was now going into the TDC and learning welding sister and getting a trade so I can come out and
Be independent.
be independent and work. And I actually feel like a turn of my heart with some, like, you know, I'm like 40 years old and I just and I feel it's time to make a change and do what I'm supposed to do as a citizen.
Changes are good. Yeah.
We appreciate your,
Make the right changes. Right. You know what's right. You know what's wrong. Yeah.
I don't have grandkids yet, but I have kids. And I was good to them for the first 12 years. So they're 19 and 17, but I feel I want to be a good grandparent that I could as much be with my kids, but they're doing well.
You're doing better with the role modeling now.
Yes, sir.
Okay. Well, it's all about choice making. You know what the right choice is, you know.
Yes, sir.
You've had to pay prices in the past and here now. Just fix this. It's just a matter of free will. Make the right, you know what the right choice is.
Yes, sir. Thank you.
You can do it. You can do it. I trust that. Okay. Good luck to you, man. Thank you.
Yeah.
Vasquez. Marvin Lewis. Joe, I'm sorry. Are you ready on Brian Manuel?
Your Honor, no, sir, we're doing it on pace.
Yeah, we're having some technical difficulties with Brian Manuel's getting him added to Joel's queue. So in the interest of time, we're going to do it on paper and I'll just scan them in to the files. You know, if we have to call MIS, it may take more time than we have a lot.
Marvin, you ready?
Oh, I just sent the paperwork.
Okay, I'll need your fingerprint.
Let's get it sent on, Judge. It's ready to go.
Okay, this is Dylan. Come on up, Mr. Wilson.
This is from the sawdust.
Yes, Dylan Wilson, right?
Dylan Wilson.
Wilson. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, right hand.
Just continue here. So you can put out. I still put on that. Oh, that's the test.
Next over here.
Okay.
On.
So you can start and put it here. She's in the line.
Thank you.
'24 CR 1592 is now called the state of Texas versus Dylan Wilson. That's you.
Yes, sir.
With Mr. Lewis, your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
He does, and we can't.
Okay. In summary, sir, this indictment alleges that on or about July 9th, 2024 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. You understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached between you and the state. You would be pleading guilty, placed on deferred or unadjudicated probation, which cans you up to 10 years.
The parties have actually agreed to 10 years.
Huh?
The parties have actually agreed to 10 years.
And fine $1,000. And is this anger?
Anger management, yes, sir.
Okay, I'm gonna. The G didn't fit in there. He said this. Among other conditions of probation, you will be required to attend and complete an anger management program, among other conditions. So is this your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and on your own free will?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Did you understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence. Without objection admitted, among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. Thank you so much. You understand?
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, sir. Yes, sir.
And I'm going to follow this agreement, if nothing further, and find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of States Exhibit 1 admitted here. And that is enough to find you guilty beyond a reasonable doubt. But I'm not going to make a finding of guilt. So long as you follow these terms and conditions of probation, you will be placed on deferred or unadjudicated probation for 10 years. You do well, it can be shortened to 1/3. There will be terms and conditions of probation. The probation officer is going to go over with you, which are usual and customary for this type of offense. You will be required to complete an anger management program, also fine of $1,000 and other terms and conditions. Do well, and you will be rewarded. If not, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison, which is not something we want to even think about. Okay. Seated probation officer, thank you. Bruce is. Okay, let me go over this one more time here. We've got Gladys Jackson. Where's Miss Jackson?
She's right outside, Judge.
She needs to be in here, please. Thank you. Roberto Mears. Bruce was out. Is he working on something right now? Bruce Cobb?
The only thing he's here on is that, Judge.
Okay. And Roberto Mears, he was absent, right?
No, he's present.
Where is he?
I'm right here.
Okay. Is there an issue on Mr. Mears we need to take up?
I filed a motion to increase his bail, Judge. We're being in contact with the complaining witness.
Where's Bruce? Outside?
He's right outside, Judge.
We need him in, please. Whoa, mama, that was filed a while back.
Yes, sir. I've been trying to get a hearing, Your Honor. It's difficult to give Mr. Poplar.
Well, these are the hearings that we can hold if the defense attorney isn't here. We don't want something bad to happen. Come forward on Roberto Mears. 22-40863. The defendant is here with his attorney and the state's attorney, Mr. Kopp. There is a motion to increase bail that was filed almost 3 months ago. And I think this has been said a few times, but because of your inability to be here, it's been postponed. We're going to have it right now. The defendant is charged here in this indictment with the second-degree felony of aggravated assault that carries with it up to 20 years in prison. And this motion states, well, it's a general motion that's just stating that it's insufficient. Yeah, I don't have enough information from this to understand what it is. So, Mr. Ham, on behalf of the state, y'all filed the motion. What is it about this motion we need to take up?
Well, the remainder of the paragraph 3 indicates, Judge, that he specifically was communicating directly with the victim on May 24th, 2025. The victim's name is Eduardo Mendez. It occurred in the general public there at a gas station on Washington. Mr. Mendez was with another individual, and when Mr. Mears came in, they saw each other. While my victim was inside the store, he walked in. He being Mr. Mears walked in, approached him, began yelling at him about the aggravated assault case. My victim tried to get away from him in the store. He tried to start a fight with and swung at him with a closed fist. He was able to move out of the way to avoid that. At that point in time, Mr. Mears left. Mr. Mendez proceeded with police reports, filing charges as far as that is concerned. That's how we picked up with this report. And my detective that's involved with Mr. Mears informed me about all this. They did not have a working camera system inside the store for surveillance footage to support it. And frankly, I would have had the victim present here this morning to relay that information, but I was unsure whether or not Mr. Cobb was going to be here. Our last communication was that he did not feel like he would make the trip today. So if we need that, I can, this information is literally a phone call away from me to obtain, Your Honor.
Can we get him open?
I can either get him or the detective here to talk about it.
Well, Your Honor, I thought we were going to go trial today. That's one of the reasons why I can't.
We are, but my trial docket exists on 2 full pages and only one to be tried at a time, but we're going to take up the hearing.
I was like,
Let me speak. Thank you. We're going to take up matters when it concerns orders of the court and the security of people involved with trials. Those become important. And we'll deal with that. But I can only try one at a time, and I'm going to name, we'll get the trial docket going, but I'm in another trial, finishing the punishment phase of a continuous sexual assault of a child. That would be finished this morning, then we'll pick a jury this afternoon. But it may or may not be this case, but we are going to take up this matter. You don't leave the building. You don't leave the building until I tell you otherwise, Mr. Sanfat, because the court does not tolerate defendants who fail to follow the conditions of bond, such as approach, communicate with the complainants. That's forbidden.
Because of the sensitive nature of all that, Judge, is why I filed it and have been trying to get a hearing for.
We're going to have a hearing today?
Yes, sir. Yes, sir. And I can get, as I said, I can get at least the detective here.
You stay in the building and be close by so that we can pull you in here for the hearings when we get to it. Right. All right. Who else has dispositions? Right? Did you have one?
Yes, sir. I turned in the packet.
Who is it?
Judge Fleischer.
He needs something.
I just Mr. Hand has it.
Y'all are going to take care of that over. Thanks. Joseph Lighton? Joseph Lighton, that's you? Did you sign everything?
Yes,
Yes.
Okay, come on up.
Raise your right, sir. So if I made you swear or affirm the truth, the whole truth, and everything so be God, you have your right thumb press.
Arias Wilson hired next week. I filed notes for that. And she said, so let me do that.
24 CR 524 is now Texas versus Joseph Lighton. That's you. Mr. Lighton, Judge Kindler, your attorneys and the state's attorneys present. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
So a
summary, this indictment in 24 CR 524 states that on or about February 20th, 2024, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, namely a firearm. Do you understand what you were charged with here, sir?
Yes.
If convicted of a second-degree felony, you face no less than 2, no more than 20 years confinement in prison, and a fine of $10,000 can be assessed. Do you understand?
Yes. Speak up, John. Yes, sir.
We're hung up somewhere. Oh, no. It's working its way through.
The channel towards us.
It's over. It's in someone else's hands right now.
In 2 seconds, Judge. It's not.
Oh.
Okay.
You go.
Oh, thank you.
Okay. You tip me off on this, guys, when y'all do this. You're going forward on the lesser included offense of Class A misdemeanor assault. Is that right?
That's correct.
Okay. Which carries with it a different set of punishment, up to 1 year.
It's monstrous for foot syndrome.
I know, but I have to. I gotta make sure you can sign all day long, but we still have to go over in the record when a plea is made. So the parties. One thing is punishment. That's a Class A misdemeanor of assault carries with it up to 1 year in the county jail and a fine up to $4,000. Do you understand?
Yes, sir.
An agreement further has been reached. Where you'll be placed on deferred or unadjudicated probation for 2 years, fined $500. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal, and then $500 is a fine. There will be terms and conditions of probation which are normal and customary for this type of offense. And if I follow this, you have no right of appeal of your case. Do you understand? You have to speak out.
Yes, sir.
Okay. How do you plead to this lesser included Class A misdemeanor of assault from this indictment, which charged you originally with the second-degree felony of aggravated assault? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty of this lesser included Class A misdemeanor of assault?
Yes. The court will note I exercise portions of the judicial confession that are not longer applicable since it's a lesser included offense. So I want to draw the court's attention to that. And those are issued by myself and the defendant. No, I feel like
Hey, I need this. I've sent it back to you. Can you send it back to me? Because I'm unable to make the necessary writings on it.
It's back in your.
Okay, I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct? State's Exhibit 110.
Without objection.
Without objection, remember. Among other things, this that you are mentally competent to enter your guilty plea. It's really involuntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You are guilty of the lesser included offense of Class A misdemeanor assault under this indictment. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witness. Be satisfied with the representation provided by your lawyer. All of this is true of states. So help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
So waived.
I will follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 2 years. There will be a fine of $500. There will be other terms and conditions of probation. You do well, it will be shortened and you can move on with your life. Okay.
Thank you.
Please see the probation officer. Thank you.
Yes, we're talking.
No.
Yeah.
Any other? Please.
Yeah. She was on the trial after this morning. They revoked her, but I think she had a child care issue, and that's why she's fine up there. She's how old is she doing?
Yeah.
Who is this? Who is this lady?
I'm sorry, Judge. On your trial docket is Miss Sterling Booker, and remember you had called her and she was not here, and she was running late, and she had a child care issue with her 8-month-old child, and that's why she was running late. So she was asking and begging the court withdraw the revocation of her bond.
Okay, what happened?
Go ahead,
Why were you late?
Because my child, I ain't have nobody to watch my child when I go to court.
You got to plan that way ahead of time. I mean, we got kids, I had kids. But, I mean, you have to plan those things. You can't wait till the last minute. Who's taking care of the child now?
My cousin.
And when you're late, sorry, you can talk about it all day long, but when you're late, everybody has to see you on time. We got to move like a train station. The train takes off. You can't run down the track and catch it. Okay. And of course, the bond's going to be the bond forfeiture is withdrawn. We'll put it right where it is. But yes, who's on this one, Sarah? Just ready for trial?
No, Your Honor, I have the same problem that I had the last case.
She's still in trial now.
I thought she could do two things at once.
She can do a lot of things at once, Cheryl. She's very talented.
He's doing all the talking here, Sarah. How does he know all this information?
It's shocking, I know.
Judge, we understand she's in trial. I understand.
Yes, but should be finished here shortly, and then we can pick a jury tomorrow.
Well, except for I'll be out a couple of days this week for my new.
No, you won't. No. You're just saying that because it's true. Who's well, we know there's an inevitable change that's going to have to be made here. Who's going to take over the case? Okay.
Here's him.
Hey.
Yeah, thanks to you. Yeah,
Put that one on
that's
me.
what I understood. It was something you did.
It's all me, right?
You said it's not the same here anymore.
I wish her the best with that. Harris County. You know,
Okay, let's go back over this. On Gladys Jackson.
Hey, so just have a seat. And well, no, I'm sorry, you gotta get reset.
Yeah, reset.
Right here.
Pick one of Daniel's cases. References.
Where is he? Getting ready?
He's at a medical appointment today.
Oh, is he going to be able to do something this afternoon?
If we need to go forward this afternoon, I will pick the jury for him. My preference is to allow him to pick it in the morning, Judge, so that it stays consistent. If we must move forward, I'll pick the jury.
Got a timing issue.
Yes, sir.
For this week.
But he's ready.
So we've got
and I can step in his stead.
Roberto Mears.
Stays ready on that. I talked with Mr. Cobb. He's visiting with his client about the bail issue and an offer. He'll let us know.
And Dylan,
Judge.
What about Dylan Banks? Does anybody have?
That's the one that needs to be reset because it requires medical testimony from Ferguson Houston. Both parties have agreed to that.
It's a special sided judge and that's why we left down the.
Mr. LeBlanc hadn't even been in here yet.
I have not seen him. No, you.
It'd be nice. Jonathan Raymond, Mr. Birds.
our preference on this, Your Honor, as well as Mr. Gertz stated that if he's available, he wants to try Miss Jackson.
That's what he wants. Who's right there? Is that
That's Mr. Gertz.
Ryan Gertz?
We're talking all bad about you right here on the line.
It would not instead of our third party here.
Or the last it's going to get.
Jonathan Raymond. Yes, Judge.
I'd say your preference was to move forward on Jackson if you're
Yes, representing her. And merits. Probably, and this is probably what you would prefer. TV judge.
You are.
I thought last year.
Oh, at the convenience of the court, Judge.
Yeah.
Maybe number.
And then Zechariah Atterbury.
I think I show that you reset that and never up here. But
I didn't do that yet, but I think it was supposed to be.
Yes, sir.
Okay.
So we're resetting Atterbury, Judge.
Well, I thought Langston had something he was going to. You're Atterbury.
We are.
Where's your attorney?
Amanda Spinach.
Say something about
Today.
speedy trial, yes, sir.
Yeah.
State
Well, I can't get your attorney. I can't do anything without your attorney sounding in, and he was mute today.
We can number that one as well, Judge. Mr. Boyd's ready on that.
Fine.
But
How
it's
about-
a similar kind of issue that.
Then I was setting him third
Okay.
on this docket
Yes, sir.
to see if we can move through that and get to him.
Okay. And then perhaps Mr. Mears is number 4 and wait and see if he's going to get his issue resolved or not, Judge.
Altman's 1, Jackson 2, Mr. Atterbury is 3, Roberto Mears is 4.
Hey, Atterbury is 3. Okay, that's no problem.
There can be 1.
No, I don't want to do.
Is it going to be disposed of without a trial or not?
No, he's saying he wants a trial.
Oh, no, that's Mr. Atterbury right
That's
there.
Atterbury
Yeah,
right there.
he's got a trial. But you had another one, Booker.
That's what we reset.
I know.
She wanted to go.
I know, but is that going to really get tried or is it just a matter of something else?
That's the case, Sarah. That's the one I'd ask you. It's probably not even on your mind, but that's the one I'd ask you to look at.
Sterling Booker.
Yes, we are not dismissing that. We are keeping it.
Yeah, because I thought the video was, but
But Langston and I have had this conversation before. He just has forgotten.
Okay, so it's still in play. For trial.
But yeah.
Joe, you ready?
Yes.
Y'all got a plea, right?
Yes.
Brian Manuel, come on up.
And Judge, you'll have to use paper on this one. We had an issue with the tablet.
I know, right?
A week and a half, we get new tablets. So.
I can't make this stuff up.
I know, but we can't get new tablets until
I
October.
mean, we're working out of the dark ages.
I don't know what else to do unless you would wait on MIS.
I mean, am I the only court that's got this? Does the court next door have a problem? Couldn't do anything in drug court?
Well, they were, Your Honor. I just couldn't get his name.
For some reason, we couldn't get Joel attached to the case. This is, like I said, in the interest of time.
You are, sir, Mr. Manuel.
Here, sorry.
I mean, first thing to swear in front of her, thank you.
Raise your right hand. Swear. Love you, guys.
It's kind of like that old Mike episode, you know, from my court.
They're gonna take your time.
It's just turning into a comedy routine.
But they moved that document on my first. I think I never saw it.
It's all serious, but it's now become a cartoon.
Between now and jury selection.
Okay, let's move forward. If we are able to.
You guys be over there, buddy.
I got it. Brian Manuel.
Hey, but you think that's you? Yes, sir.
All right.
25 CR 413 is called by an arraignment. That's the defendant who's here with Mr. Vasquez. We have a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes.
We just on paragraph 1.
Yes.
Paragraph 1 alleges that on or about January 17th, 2025 in Jefferson County, Texas, you committed a third-degree felony of injury to a child or disabled. Actually, in this, it's a elderly person, 65 years of age or older. Do you understand what you're charged with here, sir?
Yes, sir.
This is a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement given? And you will be provided all credit for time served in accordance with this case.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'll show you here what's marked as States Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection. It's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here?
Yes, sir.
Sir, I will follow this agreement. I'm going to find here that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit what admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of injury to an elderly person. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add on this?
No.
Good luck to you, sir. Thank you. What was the relation of this person to
It's my mother.
your mom? Is she all right?
Yes, sir.
Okay. Anything else? That is all.
Thank you, Judge. Thank you. Yeah, absolutely.
Okay. Any other dispositions?
We have a motion for that case.
You've got 2 bond hearings that are set this morning on the same fact pattern.
Okay, once again, trial docket here, Jason Altman, Gladys Jackson, Zechariah Atterbury, and Roberto Mears.
Can't do Zachariah Atterbury.
Of course you can't. And Roberto Mears is number 3.
Was it yours? Oh, sure.
And Ryan Manuel got this thumbs down.
Talked about it very crazy.
No, I'm bullied on Atterbury.
It's Daniel.
I'm confused about it.
What's your final answer on that?
It's Daniel's case here.
Okay, so then Jason Altman, Gladys Jackson, Zechariah Atterbury, and Roberto Mears. Unless, Sarah, you want to object again? Okay, all right, we'll do it in that order on the docket. Thank you. Here is this, and here is this file. Here is we're back to Tom Burbank. Here it is. Is this the plea docket? This is the trial.
Yeah.
I need.
We don't have much left on the other docket, Judge.
Montreal Lightfoot.
Yes, sir.
All right, so if I may, Mr. Burbank and Mr. Lodge are here on separate defendants, co-defendants out of the same fact scenario. They're both asking for bond relief. These are the separate PCs. They're each entitled to different hearings, but I just wanted to highlight that for whatever reason, they both landed on the same day.
Aren't I the lucky one? So it's Lightfoot and Willis.
Yes, sir. They're two of the 6 defendants that are charged in this.
Let's take Lightfoot first. 25 CR 715, Montreal Lightfoot. You have to speak out so she can hear you.
Montreal Lightfoot.
Okay. You are here with Mr. Burbank, your attorney, and the state's attorney is present. You were charged with the 3rd-degree felony of deadly conduct, discharge of a firearm, which carries with it up to 10 years in prison. Do you understand?
Yes, ma'am.
All right, this states that the defendant, probable cause affidavit I'm referring to in the file here, and that the defendant and another person fired multiple rifle rounds into an apartment complex parking lot, resulting in 2 people sustaining gunshot wounds, and multiple apartments, occupied and unoccupied, were struck by gunfire, as well as multiple vehicles were hit. And according to the surveillance footage here, AR-15 style rifles were used in the commission of this offense and this shooting. Montreal Lightfoot is identified as one of the persons involved in the firing of the weapons. What is his bond now? Are you asking for a reduction in bond?
Yeah.
What is his bond right now?
Yeah.
Right, because stand by.
$150,000. Yeah.
Which apartments are these? It says 4610 Maddox. I'm not. What's the name of that apartment complex?
Judge, I've just compared. We had to sort out who all was handling these. There are 6 co-defendants, and I now actually have all the cases. There is an apartment complex that is located on East Virginia and Maddox, but I apologize, I don't know the name of the church. But that is where this happened.
Yeah, Lightfoot, what do you want to say? Mr. Burbank, you're asking for a reduction of bond, and the bond is $150,000. Is that what it is?
Yes.
Go ahead.
I can put him on if you want.
What do you want to do? Whatever you want.
We're asking for a reduction to 50,000.
What do you want to do? Do you want to put him on?
I can put him on if you need to.
I don't need to, whatever you want.
I can shortcut it.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing, sir, will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And please state your full name.
Montreal Lightfoot.
Okay, and your date of birth is September 29th, 2006, correct? You have to speak out.
Yes, sir.
Okay. Yes, everything. Yeah, you nod and shake your head. It doesn't work. She's got to take everything down so that we can have it for a record. Go ahead, Mr. Burbank.
Dr. Al, how old are you?
18.
18. And do you have any bank accounts or any money that you can possibly post a $150,000 bond?
No, sir.
Do you have any vehicles? Do you have any property that you could put up as collateral for a bond?
No, sir.
Prior to being incarcerated, well, how long have you been in jail?
4.5 minutes.
4.5 months. And before that time, were you a resident of Belmont?
Mm-hmm.
And who were you living with?
My mom.
And your mom. And if you were to be able to post bond and get out, would you go back with your mom?
Yes, sir.
Where does she live?
Straightaway.
Okay, and she has a place for you to stay, correct?
Yes, sir.
You can get rid of your bed, huh?
Yes, sir.
If you were to get out too, you would abide by all the rules and conditions.
Yes, sir.
One might be a GPS. They want to know where you're at.
Yes,
You
sir.
can be able to do that.
Yes, sir.
There may be a curfew saying that you can't go out all hours of the night. Would you be able to do that?
Yes, sir.
And you're asking for a bond reduction at this time?
Yes, sir.
We're asking your honor that it be reduced down to 50,000.
Stay. Any questions?
Did you graduate from high school, sir?
No, sir.
Are my records accurate that you've not been arrested before?
Mm-hmm.
Never had any juvenile history either, is that correct?
No.
Those are my only questions, Jeff. For the defendant.
Look, the court is looking at the public safety report as courts are required to do on taking issues of bond. I'm looking on at this report. It was printed out on June 13th of 2025. And it states that the defendant, among other things, it discusses the charge here in this indictment 25 CR 715, deadly conduct, discharge of a firearm. And it also states the defendant was in July of 23 evading arrest or detention, a Class A misdemeanor, was referred I guess juvenile disposition. May 26, 2023, legal possession of a dangerous drug, a Class A misdemeanor, that was referred. On November 15th, 2021, state jail felony of unauthorized use of a motor vehicle, that was adjudicated, and the defendant was placed on 1-year probation. And on November 15th, 2021, also an evading arrest with detention, a 3rd-degree felony, adjudicated, placed on probation with the unauthorized use of a motor vehicle for 1 year. That's what this is. That true? Okay, that's not what you told him.
Yeah.
I believe he was talking about his adult side.
Whatever.
No, I asked specifically
That's
about
not
the
what he
charge.
asked. He asked for anything. It was a global question. But the point is that the public safety report is made a part of the record in this, for this hearing, and sealed otherwise, because this is going to be dealing with some juvenile behavior. So this isn't the first time you've been arrested, is what this says. And this isn't the first time you've been before a court and a proceeding for criminal matters. So you know how it is. You know that consequences actions have consequences. Good actions are bad, have bad consequences. Here, the court is looking at the probable cause affidavit where there are numerous assault rifle rounds fired in a multi-family dwelling apartment complex here in this city. At looks like about noontime, and you and another person were apparently identified as being the or among the people involved in the firing of those weapons. And the two people were shot, multiple apartments struck by gunfire, and multiple vehicles hit. In this city, this is like a bad movie. We're not going to put up with obnoxious, bizarre, violent, random behavior where people in an apartment complex, you have all sorts of people from young to old, where you have bullets flying around. This is absurd behavior in a life that we've had enough of violence. We don't want irresponsible behavior, and we certainly don't want people shot or in harm's way. And we don't want an environment where in the middle of the day, there are assault weapons being fired among the homes, multifamily dwellings in this city. We won't tolerate it. And you know from your previous criminal involvement with the crimes of evading arrest, illegal possession of drugs, unauthorized use of a motor vehicle, evading arrests, those all have consequences. And you were placed on a form of probation, it looks like juvenile. So you know that this is serious. But it's the law. We're supposed to live peaceably in this country, much less this city. And it's what we make of it. We are not going to tolerate wild behavior like this, where people are in harm's way. It only takes one bullet to kill someone. Your bond is, if it were me, I'd raise it. I don't tolerate this. The people in the city don't want chaos, especially someone who's been through this criminal system before. Shame on you. So the bond is not dismissed. It is not reduced. If he posts a bond, if you post a bond, you must have a GPS device. You will be at home confinement. You will not leave your home except for necessary reasons and with the court's prior permission. Any reason I want to have, I know what it is, and I'm going to be the determiner whether you're going to be allowed to leave the home or not. But this is chaos, and the people don't tolerate this. No civilized group would ever tolerate this. Shameless. And anybody else who pulls stunts like this. How many rounds were recovered?
That's a good question, Judge.
Numerous.
It was a lot.
That's one for each soul who was at risk.
One
could have killed a whole bunch of people.
It sent two different people to the hospital, Judge.
Killed them. But people's homes were and vehicles were damaged. Chaos. That's not tolerated. Shame on you. And anybody else involved with that. Shame on you. So no, you can sit in custody until we get this thing finished.
I'd ask that we place on the trial.
It's set for trial. Sure. Let's set for trial and get it fast tracked. I want a jury in to hear this and to decide his fate as soon as possible.
If I could, I'd like to get all the defendants on the same trial document. Yeah.
I can make sure they are set together, Jenny.
Okay, did I give you back? Did I give you that? Let me look at it just a little quick.
One other thing for your honor's education, in this young man's 130 days in the jail, he's had 9 what they label criminal incidents. So his behavior in the jail is not.
What am I supposed to do?
I'm just educating the court that you're certainly made the absolute right decision based upon his behavior in pending custody, Judge.
Okay. But it's based. I didn't know that information.
Yes, sir.
But I guess I'm not surprised based upon the public safety report, the criminal history, and the probable cause affidavit. You're free falling. So you don't care about anybody else. The others, your creator should be first, other people second, and then you third. That's what all humans should be. We should be selfless, not carrying around weapons that can kill anybody and erratically firing those in multifamily dwellings and at calls. The fact that there weren't 20 or 30 people killed here by you, I guess, is a miracle. But it wasn't because of your brilliant thinking. It's just God's will prevented that from happening. But we are going to step in and control you as best we can. Well, everybody has free choice, and your choices are poor. Anything else?
No, from the state. Thank you, Judge.
All right, Cavante Willis, come forward, please. Thank you.
As I pointed out earlier, this is a co-defendant from that same fact pattern.
I have 2 cases here, though. I only have 1.
That's because he's a convicted felon, Judge. He was charged with unlawful possession of firearms.
He's just.
See, better.
Yeah.
Same, this is the same occurrence.
Same fact pattern, yes, sir.
Come on up.
And it's
2 cases are now called.
he was handling one of the weapons, Judge.
2 cases are now called 25 CR 716 and 717. Cavante Willis, is that you?
Yes, sir.
You were here with your attorney, Mr. Lodge, and the state's attorney. Sir, in 25 CR 716, this indictment handed up on June 11th, as well as 25 CR 717 handed up by the grand jury on June 11th. In 716, this alleges in paragraph 1 that on or about May 5th, 2025 in Jefferson County, Texas, he committed the 3rd-degree felony of deadly conduct by discharging a firearm at or in the direction of others. And then paragraph 2 goes on to allege that you have been convicted out of Lafayette Parish, Louisiana in 2021 for robbery. So if you are found guilty of this 3rd-degree felony of deadly conduct, and this prior conviction was indeed deemed valid and admitted at a hearing, your punishment range becomes a 2nd-degree felony, which means you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Plus, you would not be eligible for probation in front of a jury if this prior conviction. You going to interrupt me? Yeah, let's follow the rules for a change. That's why you're here. We all follow, and we all have to follow the rules. But you get in trouble when you don't. So once again, a jury cannot grant probation in this state for someone previously convicted of a felony if this is deemed valid. And finally, in 25 CR 717, in this case, you are indicted with the 3rd-degree felony of unlawful possession of a firearm by a previously convicted felon. On or about May 5th, 2025, when you committed this deadly conduct, it is alleged you were possessing a firearm, which then enhances your punishment if you are a convicted felon, as 716 indictment alleges that 2021 conviction for robbery out of Lafayette Parish, Louisiana, shows that you are a convictee. So you are ineligible to possess a firearm if you were previously convicted of a felony in this state. It's unlawful in this state to possess a firearm in this manner if you have a prior conviction, and it's a third-degree felony, which carries with it up to 10 years in prison. So totally, you're looking at up to 30 years confinement is what you're exposed to. And in this deadly conduct, whatever sentence you get, it would not be paroled until you served 1/2 of your sentence on this deadly conduct. So if you receive a 20-year sentence, you won't see light of day in the free world until you've served at least 10 years confinement in prison, and you're not eligible for probation. So you've gotten yourself into a box here. You got to deal with it responsibly. She's a fine lawyer. I'd follow her advice if I were you. But do you understand what you're charged with and what the punishment range is here in each of these cases? Why are we here? It's a hearing on what? What is his violence?
Just on the deadly conduct, it's $50,000.
I'm sorry, it's what?
$50,000. And on the unlawful possession of a firearm, it's $100,000.
So total, it's $100,000 on each case, correct? $150,000 in both cases added up.
Yes.
It's your motion. Go
Thank
ahead.
you,
Yes,
Jay.
ma'am.
I'd like to call my client.
Raise your right hand. You solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Lower your hand.
And you're gonna have to speak up for the public order to hear you, okay? Mr. Willis, will you tell us how old you are?
22 years old.
And how old were you at the time of the incident?
This incident already?
Yes.
I'm 22.
Okay.
I wouldn't hear of this incident, so.
Okay, do you have any current bank accounts or cash on hand that you could use to help pay this bond?
Yes, ma'am.
How much do you have available?
I don't know. This is my daughter's bank account.
Do you have the funds available to pay the
Yes, my mom should have.
the entire $150,000?
Not the entire 150,000.
Okay. Do you have any property that you could use for collateral to pay the entire $150,000?
So.
All right. Who were you living with before?
My mother.
And if you were to be released on bond, if you were able to pay your bond, who would you go to live with?
My mother.
And she would still want you to live with her?
Yes, ma'am.
And she resides in Jefferson County?
Yes, ma'am.
Okay. And if you are released or able to pay the bond, you understand that that may come with some conditions?
Yes, ma'am.
Conditions that might include you to wear an ankle monitor?
Yes, ma'am.
Conditions that might require you to be homebound?
Yes, ma'am.
Okay, and you're prepared to follow any of those terms and conditions?
Yes, ma'am.
All right. Judge, we are asking for a reduction in bond down to $50,000.
And she had asked you a question. I just want to make sure that we all think about this real hard. She asked you, and you can follow all conditions that a court would set.
Yes, sir.
There's not a doubt about it.
No doubt about it.
May I?
So help you God.
Can I say something real quick?
Yes, sir.
See, I was already on probation before, but I had completed my probation. Why am I not eligible for probation again?
I'll talk to you about that after this hearing, if that's okay, Judge.
Okay.
May I ask questions?
Go ahead.
You are Cavante Willis.
Yes, sir.
Spelling Kevontay.
Yes, sir.
Your date of birth is December 4th, 2002.
Yes, sir.
You were convicted in the Lafayette Parish in Louisiana on August 26, 2021.
Yes, sir.
For the offense of simple robbery.
Yes, sir.
in cause number CR 179579 in the 15th Judicial District Court located there.
Yes, sir.
Yes, sir.
Yeah.
And on that, you received for that offense, you did receive looks like the equivalent of some kind of probation where you were sentenced for 3 years, but hard labor, but it was probated for 3 years.
Yes, sir.
You were just referencing to the court that you had finished that probation.
Yes, sir.
When did you finish the probation?
I finished in 2024 around March.
Okay, go ahead.
Show your picture that's in there. Is that individual you?
Yes, sir.
So you're not disputing the fact that you've been convicted before of simple robbery from that
Yes, sir.
deal that we've been talking about. All right, so let's talk about your conduct in jail. My records indicate that you have been in custody for 129 days, true?
Yes, sir.
My records indicate that you have been reported for different incidents of not following the rules starting in June 11th of 2025, all the way up until right before you appeared here in court on the date of September 21st, 2025, yesterday.
Yes, sir.
Do you want to modify your answer to that you gave the judge that you have the ability to follow rules?
Yes, sir. You see, most of them cases I got in fights, but like I got jumped and all them situations, like wasn't even my fault. Just I'm not from around here, so just I don't know how to explain it. But
I don't have any other questions along those lines, Judge.
Okay.
Anything else would be about the offense.
Let me ask you about the probation that you were previously on. How did that get disposed of?
You completed the terms of that
Yeah.
probation, correct?
I completed the probation.
Or for 3 years? It was a 3-year term of
Yes, sir.
probation?
It was 3 and 7 if I violated.
Was it February of 21?
Yes, sir.
No, that's the arrest date.
I believe that.
When were you placed on
conviction date
probation?
was
I'm
August
sorry.
August
21.
August of 21.
August of 21, which means he's been a little over 4 years.
But when did he get off of, when was he released from probation?
Last year.
24.
24.
The actual notes in our records says he was released unsatisfactory. That's from the custodian of the records for the PIN packet that
Yeah, I'm
was
not sure
received
what
and
that
uploaded.
exactly means. That doesn't sound good, but I don't know what it means, really.
And in fairness to all of us, Your Honor, I also don't know what that means. From his understanding, he completed the probation. He didn't get any further.
Sentence?
Yes.
So it ended with a probation, but it's a regular probation. He was found guilty,
Yes.
not deferred.
Yeah,
You were
regular
found
probation.
guilty beyond a reasonable doubt. That probation was not dismissed, though, and exonerated. He wasn't.
Correct.
It,
It's our equivalent of a straight, it's our equivalent of a straight probation, yes, sir.
So you have, and that's why this is alleged here as a prior conviction in paragraph 2, which they're going to argue at trial feasibly that you're not eligible for probation because of this, if it's proven true beyond a reasonable doubt, and that the punishment range is enhanced. It's higher because of that.
And it's that conviction the state is relying on for him to be a felon in possession of firearm, Judge.
And just for judge's clarification, what age were you at the time of that conviction?
17.
17 at the age of that conviction, Judge.
Did you know better?
Yes, sir.
What?
At the time, I know better.
I was 17 months. I know better than
Yes, I know.
commit
Now,
robberies. I mean, how old do you have to be to know that a violent crime is real? All right. I have the public safety report as well for this record, which was printed on June 13th, 2025 of defendant Devontae Todrick Keon Willis, date of birth December 4th, 2002, FBI number R as in Robert, 0320. P as in Paul, J as in John, W as in William, 1. It is a document of 3 pages, which will be made a part of the record for all purposes for this hearing, since the courts are bound to recognize and review the public safety report of an individual who is the subject matter of a bond hearing now under Texas law. And it has the criminal history of the defendant as well as the new charges. You're asking, Ms. Nalaj, for?
Yes, Your Honor, we're asking for a reduction in that amount to 50,000, something that is potentially capable for him to pay.
I understand. The court has also reviewed the probable cause affidavit in this case. And again, this is a most aggravated, serious case where multiple rounds of AR-15 style rifles were fired into vehicles and apartment units of a multi-dwelling apartment complex in this city of Beaumont, Jefferson County, Texas. And 7.62 and 5.56 caliber rounds connected to assault style weapons were fired in this case. And the current bond, the court feels is proper based upon the circumstances of this case and the defendant's criminal history. And shame on anyone who is so irresponsible to fire assault weapons at midday into apartment units and vehicles at a multi-family dwelling facility like this apartment complex here in Beaumont. Your bond is not reduced. If you can post the bond in this case, you will be placed on home confinement. You must have a GPS device. You cannot leave your residence under those circumstances unless a permission is granted ahead of time by this court. Do you understand where you are? And this is all due to the circumstances of this crime and your criminal history. Anything else?
Yeah.
That is all. Thank you.
I have a question.
Yeah. You can talk to her.
Yeah,
Okay.
I can talk to you.
Carly Fowler.
That was me.
That was reset. And then we've got, I had Monica Vincent. Did we reset that? And then on Anthony Spruill, John Best.
No.
Go ahead.
No idea.
I did.
Okay. We're in recess. Please, let's get ready to pick up the trial. Thank you.
Mr. Cobb, if you want to.
Come on up. Here is.
No.
Which case is this?
This is the one that's on your trial docket with Santana Pierce. There's been an offer communicated that my understanding is rejected.
Okay.
It's number 4 on the trial docket.
Okay.
We need to have a hearing on the motion to increase his.
Right now?
Well, my witness can be here this afternoon.
Okay, that's what we want to do it. I'm going to reset it till 1 o'clock. Thank you. Thank you. That is all. And let's get ready for trial. Thank you. Okay.
Judge.
Yeah.
Noffsinger. I tried to see if I could get his help this morning, but he wasn't scheduled to be here. So here with us is the Chief Public Defender, Mr. Keith Stickley. You were originally charged with possession of methamphetamine as a felony. The case started in front of Judge Pattison, and then somehow it got put in front of me. You entered a plea to that charge, and we set the sentence for August 11th of 2025, and you didn't show up. So we waited a few days, and then we issued a bench warrant for your arrest. We also did a notice to forfeit your bond with the bonding company, but they usually don't do anything about it. How did you come to get arrested this weekend?
I was at Walmart.
In what town?
Kalamazoo. I've been in jail for like 10 days now. I was in Kalamazoo on hold for St. Joe to come and get me for like 6 or 7 days.
She might have a pending charge there, Your Honor. I'm not exactly sure yet.
Do you have a charge in Kalamazoo?
I'll have a court hearing. I should get paperwork.
All right. I tried to find a time that your lawyer was going to be here, and I couldn't find one. So I'm going to cancel your bond. You don't have a presumption of innocence. You've entered a plea, and then you didn't appear for sentence. Were you in jail in August in Kalamazoo?
I had 3 rides set up and they all fell through on me.
All right. Do you still live at Edward Street?
I do right now, but I possibly am getting an apartment, and I was supposed to start a job this week.
Excuse me, where is that?
I was gonna start cleaning houses with for my friend Scott Strickland.
I have a Matthew Strickland in jail, but not a Scott Strickland. I don't know exactly when I'm going to do this sentence. I want to talk to Mr. Noffsinger. So your bond is canceled. We'll coordinate a sentencing date.
Is it possible to just do my sentencing date right now? I've been in and out of the hospital, and I got a week to get this stint taken out. I just
no.
in the hospital last night. The jail had to take me to the hospital.
I'm gonna work on it. Do you have a doctor's appointment?
They told me that I need to get the stint taken out within 1 week. I've got a urinary tract infection. They prescribed me antibiotics and stuff.
The stent is in your heart?
No, the stent is in my kidney. It goes from my kidney all the way down my urethra.
All right. The sheriff probably wants you out of there. I was gonna use the date of October 3rd, but that's quite a ways away, and it's also very busy. So we're gonna call your lawyer and see when he's scheduled to be here and when we can fit this in. I will try to do it this week if I can. So you've been in jail for 10 days with the stent in your kidney?
Yeah. And it's really painful.
I don't doubt it. All right. I'm going to hold on to you until I can line up your lawyer and try to do this sentence. Bear in mind, this is a 2024 case. You went AWOL for a while before we got the case back on track. You went AWOL in December of 2024. We didn't catch up with you until last summer. I let you out of jail.
I'm not gonna go AWOL. I gotta get this taken care of. I really gotta get it taken care of. I don't need it to go septic.
All right. I understand. I'll see you when I can coordinate a date with your lawyer. All right, Mr. Stickley, thanks for your help. We'll see what Luke's got. In light of her Kalamazoo charges and medical problems, our jail probably doesn't want her in there. Good morning, Ms. Canfield.
Good morning, Your Honor.
We have 5 sentences and you got Mr. Zambrano. Let me see if you got Luke or Paul. Zeringue is 10:30. Is he here?
No, sir.
Is he in jail?
No, sir.
He may be in the Allen County Jail. Let's make a record on that. Laura, would you help me? Why don't you come on up, Mr. Gibson, and we'll call that case. We got a sentence this morning on Daniel Zeringue, and he was wanted in a bunch of other counties. And he was in the Allen County Jail in Fort Wayne. Could you contact them and see whether he's in their custody?
Absolutely.
Scheduled for 10:30 this morning is the matter of People versus Daniel Adam Zeringue. It was a retail fraud in the first degree, reduced to retail fraud in the second degree. Mr. Zeringue is represented by attorney Paul Gibson. Also present here today is Angelique Camfield from the prosecutor's office. I asked for a pre-sentence investigation report in this case because there was so much going on. Autumn Kiefer did prepare the report for us. And Mr. Zeringue has all kinds of things going on. He had a Kosciuszko County charge of theft, Elkhart County, Indiana, theft, Allen County, which is Fort Wayne, theft, Huntington County, theft, Kosciuszko County, theft. So he was either on probation or wanted in all of those jurisdictions. In fact, this case came up when the Indiana authorities contacted the Sturgis Walmart authorities and hey, said this guy's been stealing our stuff. So whoops. Good morning. What's your name, sir?
Daniel's a writer.
Oh, very good. Would you come up and have a seat with your lawyer?
Could I talk with them real
Yes,
quick about the
certainly.
report? Because we didn't have a chance to talk on Friday.
Very good. All right. Laura, the guy just walked in 4 minutes late, but he's not in their jail. Ms. Camfield, did you see the pre-sentence report?
I did, Your Honor.
Hi.
Hi.
Why don't you have a seat up here in the front row? Angelique needs some company. Thank you for this report. It was kind of a not very pleasant assignment, but you helped make us some sense out of it. Good morning. But you have a seat on this side over here. Thank you.
I thought I was gonna meet with my attorney first.
We'll make sure that
I
happens.
was trying to change my plea
All right.
and I didn't know if that was okay.
Well, we'll
I
just,
had a phone contact with one, so.
all right, your lawyer is Mr. Gibson?
Mhm.
Yeah, he's here. He's talking with the client right now. And we'll let you have a chance to do that. So just have a seat.
I couldn't tell you because it won't tell me everything I wrote on the side as well. I can get from. So. That's what
Right, so we did not receive his packet back.
She also indicated she had reached out to him without success. Thought he possibly might appear this morning. Well, maybe we can jumpstart this. Shayna, I did that in custody arraignment on Danielle McNeese. However, I couldn't find a spot where Luke was scheduled to be here. Michelle showed me a way to do it with a bunch of complicated steps. And I didn't do it that way. I just looked for him. I'd like to get this set for sentencing even this week if we could. All right, why don't you come on up?
Okay, yes. Mr. Zane.
This isn't a good use of our time. You show up late. I sit here like an empty suit for 18 minutes, along with everybody else in here, waiting for you to talk to your lawyer.
I apologize.
And that puts us behind on the next 5 cases. And we've been sitting here staring into space, waiting for you to consult with your lawyer. This should have been done in advance. At any rate, let's address it. Two of it. Here it is on the bottom. This is the matter of Peoples Daniel Adam Joseph Zeringue, or Zering, is how you say it?
Zering.
Zering. He's here with his lawyer, Mr. Paul Gibson, also present is Assistant Prosecuting Attorney Angelique Camfield and Autumn Kiefer, who prepared the pre-sentence investigation report in this matter. Defendant was charged with retail fraud in the first degree. The matter was reduced to a retail fraud second degree. The defendant had so much going on, I referred the matter for a pre-sentence investigation report, and Ms. Kiefer has prepared the report for us. Mr. Gibson, what would you like me to know?
Mr. Zering indicates that he recently started a job at I think it was AIA in Syracuse, Indiana. He indicates, I think he's been there approximately how long?
About
A month. The defendant would like to note that it said in the report that he committed 3 of the offenses in other counties when he was out on bond in this case, but from what I can see, he was arrested on this case in July of this year. And so some of these offenses may have happened after this incident, but I don't believe he had actually been arrested on this incident. So I don't know, it would be right to say that he was on bond. But as far as the case goes, the defendant has served lengthy jail or prison sentences in the past. He indicates that after this incident that he's been trying to, get clean and sober, and he's been working on that, and he says he's been doing well. And he indicates that, he was stealing here because he was trying to support a drug habit. And so he's asking this court to consider fines and costs, or if it's a jail sanction, a shorter jail sentence. And Mr. Zering does have court. He says that this can be verified, that he has court tomorrow in one of the Indiana cases. He says it's not the type of court date where he's expected to go to jail afterward. So he's asking if the court does sentence him to a jail term in this case, that he be permitted to check into the jail after he attends his court hearing in Indiana tomorrow. Thank you.
Thank you. Ms. Campfield, what's your thought?
It does appear that there is a period of time from at least April through July of 2024 that entails and encompasses not only our offense, but all of the purported offenses in Indiana as well. I can note that while we were waiting, I did look up the level of offenses for these Indiana charges, and it does appear like several of them are what they call a low severity felony 6 level. So there, I suppose, is a potential that if there's a resolution of some of those cases to a felony offense, he could face pretty lengthy jail or prison in Indiana on those cases. I know the prosecutor down there, if they were all the same county, would probably make a package offer, but unfortunately, they're all different counties. So I'm not sure what he's going to be facing there. I do see throughout the history that was reported in the PSI that by Ms. Kiefer, that there has just been a long going battle with addiction for this defendant. He has gone to prison and abstained from use. Hopefully things weren't available there, but he claims that he was sober while in prison for these long terms, but then when he got out, started using again. So that is a concern. I'm glad that he is claiming to be sober at this point. And hopefully he's, as the court often says, tired of being tired and addicted. You're always going to have an addiction, but at least you can live a sober life and be productive. He's trying to go towards that, but we still have these offenses from last year that have not been dealt with. I think a jail term as recommended by Ms. Kiefer is appropriate in our county because any probation that would benefit him, I think, would have to be out of one of the Indiana cases where he resides and is working. I just think appropriate supervision would be there in his state of residency rather than here. I suspect driving here this morning is what made him late from Indiana. I think that the recommendation is appropriate. There was over $1,000 stolen here, according to the report. He did state in his pre-sentence that a lot of that was food, but it appears that there were also other items that were not, that he was going to sell to support purchasing drugs. So I think the rec's appropriate and would ask the court to follow it.
Ms. Kiefer, your report kind of stands for itself. You're recommending 30 days in jail. The items that he took were regular stuff: toothpaste, mouthwash, cat food, mattress, and then some things maybe that could be sold. Captain Crunch. Boat accessory light, water. It looked like he's going camping. Stainless steel flask, some other stuff, but mostly food and health and beauty items. Mr. Zaring, what's your input here?
I just very regretful for the bad decision I made, and all these other charges I got were all around the same time, and I was just struggling at that time and just made poor decisions. And with the 8 months that I had served due to violating probation in Whitley County due to catching those charges, really let things sink in at with what age I'm at and the decisions I've been making, and just a huge amount of regret and remorse for not just what I caused to myself, but for others in my life as well that love me. And I'm just praying that the court considers probation, and I wouldn't have a problem driving up here. I know I was late today and I apologize for that, but a lot of these other counties that I'm going to court for in Indiana are also talking about giving me probation. So I was just hoping that I can get a chance to be on probation and continue working at my job and just continue proving myself to be a productive citizen. That's it.
All right. This was very clever. I don't want to say what you did because I don't want to give other people ideas. I haven't seen this before. You walked in like you owned the place. There's videos of you walking in your champion t-shirt, picking out all this stuff, duping the clerk and walking out with $1,000 worth of stuff. You drove up here to steal. Some of it was, I guess you could have sold it, but some of it was just stuff you need, a mattress, mouthwash, cat food. You just were doing your stealing and you thought you were so smart, you got away with it. And you walked out of there thinking you did get away with it. The other Walmarts connected our Walmart. I don't know if they checked Three Rivers. And there you were. And then you got arrested on this warrant. Well, you're not quite as smart as you thought. I don't want you on probation. You don't live here. You don't work here. I'm not going to fix it. I'm going to leave it to those jurisdictions. But this was a felony of some consequence as a habitual. You brought your crime to our community and thought you outsmarted everybody, but I guess you didn't. I'm going to order 33 days in jail, credit 3, leaving 30 days to serve. The fine is 0. I'm even waiving your attorney fee. There is $1,100 restitution to Walmart.
Can he check himself?
He can go to jail right now. I'm not gonna dick around with losing him to the state of Indiana. You earned this. You came up here and poked us in the eye thinking that you were smarter than everybody else, but I guess not. You owe $1,225 by the end of the year. You always may have enough money to post bond. You posted bond in all these jurisdictions, including a $2,500 bond here. I don't think it's likely we're going to get this money. I think you're going to end up in jail or prison in one of these counties in Indiana. This scam worked pretty good until it didn't. Do you have a car here?
Yeah.
You have to call somebody.
Well, I have a friend out in the door, but he didn't come in, so I need to have somebody let him know.
All right, we'll let him know. You tell the bailiff where the car is and I'll let the guy know. All right, you're good to go. I don't want to say what he did, but what he did was very clever. Thank you, Autumn. Mr. Gibson, Miss McKay wants to talk to you. For what it's worth, she has 14 days jail credit. We have no victim input, and my contemplation was to give her time served. She has discussed the fact that she wants to withdraw her plea and maybe go back to have a felony conviction, but she can speak with you and we'll take care of Mr. George's cases. Well, Mr. George, you got the next couple. We are actually almost on time. Let's start with Kayshawn Rhodes. This is file number 251111SD. Good morning, sir. All cases are different, but similar. Mr. Rhodes is charged with operating while intoxicated, was reduced to operating while impaired. One of the factors, and I've been commenting on this, we've become desensitized into high blood alcohol levels. It's like, oh, but everyone today is quite drunk. This is a point 197. Off in a ditch out where I drive every day. I think Mr. Friesen did this one and he's still on his trip, but we do have a screening report.
I think this one was Matt.
Oh, Mr. Huff. Is Matt here today? All right. Maybe he's- all right. Yeah, it is Matt. All right, Mr. George, what would you like me to know?
Well, thank you, Your Honor. I'll start by saying I've got 3 clients today, all for operating while intoxicated cases and a lot of similar situations. So I apologize in advance if I say a lot of similar things. But Mr. Rhodes is still young, not much of a criminal history, if at all. And as the court may remember, this was a situation where he was down here in St. Joe County for a baby shower. There was something that happened there. He tried to get back to Kalamazoo and obviously didn't get all the way back. But as bad as it was, it could have obviously been much worse. And we're very fortunate that Mr. Rhodes is here to talk to the court today, and nobody in the public was hurt. Mr. Rhodes does have gainful employment, so Summit Polymers in Portage, and the baby shower has now produced his second child, and he's excited about his family continuing to grow. But I think having those children makes him realize these are the types of situations that he doesn't want to put himself in anymore. And I think he was upfront honest with Matt, told him that here's the truth, the ugly and all. So I think Matt has done a really nice job at crafting a recommendation. I think it's appropriate based on my client's lack of criminal history, the circumstances that bring him in front of the court, and I think it addresses all the needs. So we ask the court to adopt the recommendation.
Here's Mr. Hoff. Ms. Canfield, do you have any input on this one?
Your Honor, I haven't had an opportunity to review a report. If I may have a moment.
All right, well, let's hear from Mr. Huff. I can tell you my concerns on this, several. He was way drunk. He's a regular marijuana vapor, and he's vaping marijuana in addition to this. He's got booze all over in his car. Buzzball, Johnny Bootlegger, Don Julio Tequila, and Fireball are laying all over where his car hit the tree. Plus, he hit a tree. He was going to drive all the way from Sturgis to Kalamazoo in this kind of shape. THC'd out 2.5 times the legal limit. 4:30 in the morning, he hits a tree. He's fortunate he got an offer to impaired driving. This is very irresponsible, immature behavior for someone that has 2 kids. So that's my concern. Bad alcohol, lots of marijuana, all kinds of open booze in his car, and very bad judgment. So those are my concerns. Mr. Huff, you wish to speak to that further?
Yeah, I'd say, just in summary, I think that, Mr. Rhodes had a bad night. I think the context matters in this situation. He claims that the alcohol in the vehicle was not from that incident, that he was consuming.
And I'll assume that, but he's driving, it was from some other incident, or he just leaves it all in his car and then it comes out when he crashes into a tree.
He indicated he had a baby shower earlier that day. There was some alcohol consumption there with family. And then this was a situation where he indicated his intent was to stay in Sturgis. He got into a situation with it where he wasn't getting along with his girlfriend. They were in some sort of an argument. And then given the fact that he was already severely intoxicated, he made the wrong decision to drive home rather than just to stay back there. So given his age, I think, while it doesn't, take away the aggravating circumstances by any means, this is something that is unfortunately relatively common. You get somebody who's in this sort of situation to make a bad decision. And we're fortunate that things didn't end much worse, where somebody lost their life, either Mr. Rhodes or somebody else. As the court's already stated, this is an opportunity for Mr. Rhodes to look at this situation and learn from it. He has 2 children. He has a girlfriend that he's been with for a significant amount of time, and he's got a good job up in Portage rather. So this is a time, I think, where a probation would be appropriate, even though he's not in our county. I think that a timeout from alcohol or perhaps even marijuana would be good for him, clear his mind and help make some better decisions so that he can get to the next stage of his life. You already mentioned the aggravating case factors, so I'm not going to bring those back up, but obviously there were a significant amount of aggravating case facts in this one.
All right. Mr. Rhodes, I'm going to give you the last word, but before we get to you, see if Ms. Camfield has any additional input.
Thank you, Your Honor.
Matt, did you get a driving record? I don't see one in the
I
file.
have a driving record, Your Honor, and I was just going to state that for the court. The history shows probably around a 2022 driving without a license or endorsement, and then a speeding 70 and a 55 at a later date. So no priors, which I suspect is why there was an offer of impair here, even given the high level of intoxication. I will note the laboratory reports show that not only was he at a 0.197, but he also had marijuana in his system that was still metabolizing, which would indicate to me that he was most likely high as well as intoxicated with the alcohol. So that's, as the court's already stated, and Mr. Hufford, very concerning. I think Mr. George also has recognized that this could have been much worse for his client. We could be here in a different situation. So it's fortunate for his significant other and his children that he's still here. I frankly think that the deferred jail should be served immediately prior to a probation starting, and it should be scheduled on a weekend so he doesn't lose his employment. But I think he should check into the jail on a Friday night and leave on Monday morning so that he has an idea of what potential penalties could be if he violates his probation, if this court puts him on one and orders no alcohol and marijuana consumption. I think the rest of the recommendation is supported and I ask that the court follow it.
All right, Mr. Rhodes, you get the last word. What would you like me to know?
Oh, yes, Your Honor. I would just like to say that this entire situation has already been a big wake-up call for me, and I'm very remorseful and grateful, and I fully recognize that I put other people at risk in my life as well. And I just want it to be over, and I'm ready to be better.
I guess can't ask for more than that. I don't want you to put you on a probation to set you up to fail. I don't think you can stop smoking weed, and it's going to be a big difficulty for you to do this probation. I tend to agree with Ms. Camfield. You deserve a jail sentence. There's a presumption, even in drinking driving cases, that there is no jail. That wasn't my idea. That's the state legislature and the Criminal Justice Reform Act. But I've overcome the presumption by your high blood alcohol level, the fact that you were also using marijuana, the fact that you hit a tree, the fact that you were going to drive all the way from Sturgis to Kalamazoo in this kind of shape. And apparently on other occasions, you just drink whatever you're drinking and leave it in your car. No wonder you and your child's mom got in an argument because you were way drunk. I'm gonna just order 3 days jail, credit 1, leaving 2 days to serve, which can be served on the weekend, scheduled by the probation department. I'm not gonna put you on a probation because I don't think you can do it. So the other option is just give you more jail, and that's not gonna answer it. If a weekend in jail doesn't give you a wake up, I don't know what does. $300 fine, $75 crime victims' rights fee, a $50 state minimum fee, a $100 screening fee, $150 attorney fee. $255 police reimbursement. And I'm going to order the victim impact panel, which is $32. Let's add all that up. That can't be right. 300 plus 125 plus 100 plus 150. Plus 255 plus 32 is 962. I don't believe I have any bond money here. This is all money that goes away from your family. Matt suggested a timeout, and that's what we do. You're going to need to just give yourself a timeout. I'm going to give you until the end of the year to pay that $962. You're also going to attend our victim impact panel. You can do one in Kalamazoo. They've got them there too. You're going to have a weekend in jail to think about it. What are you doing this weekend?
I could probably most likely just get over it this weekend.
All right, we're going to begin at 7 o'clock Friday, September 26th. He'll get out at 7 o'clock Sunday. Your driver's license is going to be restricted, so at least you'll be able to get back and forth to work.
Your Honor, I don't mean to interrupt you, but do you want him to attend St. Joseph County Victim Impact Panel? Or are you okay with him attending?
I'm okay with him attending a Kalamazoo one if you can find one. Friday, 9/26/25 at 7 p.m. Report to jail for a weekend. Hopefully this will be enough to make you realize how lucky you were they didn't kill yourself. So you're going to spend this weekend in jail to think about it. You go downstairs with Mr. Huff and he'll talk about the victim impact panel and the rest of what you need to know regarding the jail. Your fine is due before the end of the year.
Thank you.
Your Honor, you still have adjournment?
I do. Let me give it to you.
Thank you.
You can have that one too. All right, let's Mr. George, what does your client want to do? I mean, Mr. Gibson?
I believe she will be, is okay being sentenced today.
All right. Well, let's stay in our drinking driving mode here. Zoe Lynn Parker. Good morning. Mr. Rhodes was filed 1111. You were 1112. I think you both got arrested on the same night, June 11th. Must have been a busy night. You also were charged with operating while intoxicated, and the matter also was reduced to impaired driving. Something occurred to me while I was reading this pre-sentence that maybe what's your mom's name?
Heather. I'm sick right now. I'm sorry. I have a sore throat, but her name's Heather Bradley.
Yes, that's our Heather Bradley.
Oh, I'm aware.
All right, I didn't figure it out as I'm reading it. I thought, holy smokes. I spent a lot of time with your mom.
I'm aware.
And I liked her. And she's in a bad relationship, and she had a bad alcohol problem. And she was at my.
She does.
What?
She does, yes. Yeah.
Well, she did a good job when she was in my sobriety court until she didn't. It ended up going back up to Judge Stutzman, and she did a significant amount of jail time.
Mm-hmm.
But she is a good person who has an alcohol addiction.
Yeah.
She's still struggling with it.
Yeah. Yeah.
You don't want to inherit it. And you guess what? You
No,
did.
definitely not. No.
You did. But apparently Autumn realized that I didn't. But again, we're lackadaisical about our high blood alcohol level. This one's 0.20. She's 26. Mr. George, what would you like me to know?
Thank you, Your Honor. Well, I think the court's kind of started the conversation that I was going to begin here. And Zoe's in a situation, as the court's seen many times, where there is a family history of substance abuse. And unfortunately, she has been dealing with that herself. This was a situation where I believe mom was involved, where she was over trying to help give a ride. And, you know, it was an ugly situation on its own, but obviously it could have been uglier. Zoe does have 2 children that she cares for. She also is employed as a receptionist over in Branch County. And I think based on Zoe's history, not only family history, but some of the history she's been through, I think Autumn, recommending a probation is appropriate. I think Zoe could benefit from services, whether it's education, whether it's specific individual counseling or treatment on top of that, because she is young enough where, as the court knows, if you're dealing with these types of issues, it's not like it's something that goes away. It's how do you effectively deal with that when life struggles or certain situations come about. And I know that she wants to be, a better mother for her kids and not put herself or her kids in this type of situation. So the only thing that we would ask is if the court would consider to defer the 1-day jail. Other than that, I think the recommendation is appropriate. We'd ask the court to adopt it. Thank you.
Ms. Canfield?
Your Honor, I agree with the recommendation and think that it should be followed. I do see that with 2 parents who struggle with addiction, obviously that was passed down to Ms. Parker, I believe, probably genetically as well as behaviorally. What's concerning here is it looks like there were several opportunities at which she could have declined additional alcohol and chose to consume more when she was going to be driving again. So we do think that the recommendation for probation is appropriate and a day of jail to be scheduled with 2 others that would remain deferred. She's struggling and she's admitted that she's used controlled substances previously as well until she found out she was pregnant, and we don't want abstention from alcohol turning into someone turning to other substances in place of that. So I do think that supervision is appropriate.
Let me ask a minute. What is Consume? Is it a provisioning center?
Yes, yeah.
All right. So do you also use marijuana?
No, I stopped since I knew I was gonna get on probation.
All right. So had you been using marijuana that night
No,
or that day? Had you smoked earlier that day?
no.
There's no indication of it, but when you work at a marijuana store, I presume that you're a marijuana user. That may be a leap of faith.
Occasionally, yes, but not a day. I have kids, so like, it wasn't like, I don't want my house smelling like it, or, you know, so.
All right. Okay, I'm sorry. Go ahead, Ms. Campfield, because I was wondering whether there was an underlying marijuana current here or not.
And that there were other just harsher substances, methamphetamine and cocaine were tried when she was younger. I don't want her turning back to one of those if she's not consuming alcohol any longer as a coping mechanism, especially with the children. So I think that the recommendation is appropriate and ask the court to follow it. This was a very high blood alcohol.
Once, a long time ago, when I was still prosecutor, I did a deep dive into the year's drinking driving cases. And I was surprised at how many first offense had an MIP prior. Ms. Parker's got 3 of those. And so the alcohol problem starts to show itself before they're even old enough to drink it legally. Ms. Kiefer, anything else you'd like me to know?
I think this court is fully aware of her parents, their addiction. She comes by it. Unfortunately, she can't help it, but we need to stop it the best we can.
I'd like to hear that her mother was doing better. I spent a lot of time with her and you weren't here yet. It was Gina, but you were aware of her. Nice lady. She called me once over the weekend on the phone. She called me at home, which really you aren't supposed to do, but I talked to her at some length that day and she was struggling. And she just couldn't get over the hump. I'd not like to see that for you. You got 3 and you're all drinking like it's just an everyday thing. The neighbor's drinking, your mom's drinking. It's like, well, and again, this could have been a lot worse. What would you like me to know? Now you're a mom, you got 2 kids. The last guy, I kind of gave him a hard time because he's out doing this stuff instead of home taking care of his kids. What do you want to tell me?
I apologize for that night. I think it could have went very differently, but, yeah.
Where were you going?
So I tried to take her home, but she couldn't go home. And then I went to her neighbor's house. When I left, I don't even know where I was going or why I was driveway. But then I drove back. I looked on my little, I have like a GPS thing for my insurance or whatever, and it tells me where I go. And I just drove for 3 minutes. So, and then I drove back. So I don't know.
Well, I think this is worth a probation. And your mom's not doing you any favors. I'm gonna follow Autumn's recommendation, including the day in jail as a wake up. Again, there's a presumption of no jail. Here, we have very high blood alcohol level. You have 3 prior convictions for minor possessing and consuming alcohol. And if otherwise, the facts are bad. So I'm going to order a 24-month probation, which means you can complete it in 12 months. I'm going to order 4 days jail credit, 1 leaving 3 days to serve. Under the 4 days, 2 are deferred. So the other day is going to be scheduled by the probation department. We're going to do some drug and alcohol testing. At least a couple times a month. It's expensive. Substance abuse counseling and treatment as recommended. I want you also to attend the victim impact panel. Do the children each have the same dad?
No.
Are the dads involved in the kids' lives?
No. So Cyrus's dad, he's not very mentally competent. I feel like he's schizophrenic. So, and then my daughter's dad, he just, no.
Well, you don't want to visit this on your kids. Your mom's mom gave it to her. She gave it to you. Your kids don't deserve to be on this path. $300 fine, $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, $150 attorney fee, $960 probation oversight fee. Autumn, I don't see a police reimbursement in here. Do you have one, Ms. Canfield?
I don't see one in the file, Your Honors. Let me double check.
And again, this is money away from your family, but so is alcohol. The cost of booze is gonna be less than the cost of this probation.
I don't see a request, Your Honor, although I do
All
know
right.
it was a blood sample. So.
$1,667 could be reduced by $480 or more if you complete the probation earlier. That's 2 in 1 year. You're not to drink any alcohol or use any controlled substance, including marijuana, and that doesn't seem to be an issue for you. I wish I had been more successful with your mom. You resemble her. I wish better for her and I wish better for you, but you're gonna owe me a day in jail and I want you to try to work on getting out of this path you're on. Make it better for you and your kids. All right, Ms. Parker, I want you to go with Autumn and she'll get you plugged into what you need to do for this.
Thank you. Thank you, Your Honor.
All right, Mr. George, let's do Tommy Willis. Good morning, Mr. Willis.
Morning, Your Honor.
This one was done by Daniel, I think. Yep. Here we go again. 0.192 blood alcohol level. This gentleman's in the Army Reserve. And he may also have inherited the alcoholism gene. Mr. Willis, what would you like me to know?
Yeah, it was a real struggle for a long time. I started going to AA meetings, and I have them all logged in this planner here. It's helped me a lot, and I saw the good, the bad, the ugly of experienced individuals as alcoholics, and how they've turned their life around. And it's been a real inspiration, especially from my father. As I told you before, he's in sobriety court. He's actually graduating tomorrow.
Are you coming?
I mean, I can try, but I mean, I'll be at work most likely.
Well, I knew of you. I knew he had 2 kids, 2 sons.
Son and a daughter.
A son and a daughter. Then his girlfriend had 2 kids that he had to get out of the house. And he's done a great job. He's done a great job. He's been a role model to others. Has he taken you to meetings?
Yes, he goes to the meetings here in Centerville. He drives right by my house to go there, so he'll pick me up and take me there. But I've also gone individually to other meetings. So.
All right. Well, that's good to know. Mr. George, what would you like me to know?
From the very first time Tommy called my office, he's obviously taken this really seriously. I think that's indicated in Dan's report. It seems like right at the time that the police arrived, he was upset because he was thinking about, his wife and his daughter. So there was that reflection. But as Tommy's already, mentioned a little bit, there is family history here too. And, we spoke a little bit before, and he hasn't told me this, but, my sense would be that, this was maybe the lifestyle that he had been living for a little while. And, a circumstance came up. He drove when he shouldn't have. And, it was a big wake up call for him. The silver lining is all we're dealing with is an impaired driving, but I think it has given him some insight into his family history, how that's affected him, but his also responsibility to address that on his own. And as the court's well aware, Tommy is in the National Guard. He's kept his commanding officer advised of what's going on in this case. I'm not sure what the sanction will look like, but there is going to be some penalty there. So before you as an individual who I think is taking this very seriously because he understands, what's at risk for him if he doesn't get this resolved and have the tools that he needs to address this effectively. So I think a probation would be fantastic for him, get him additional education and information. And the AA is something that he had been doing on his own. I hadn't mentioned him to do that. That's something that he's done on his own. And maybe that's a bond that he and his dad can have, sober bond going forward and be supports for one another. So we'd ask the court to adopt the recommendation as we believe it's appropriate. Thank you.
Ms. Camfield?
Your Honor, this is another young individual who is addicted and dependent, and the parents have some import in that occurring because they too struggle with addiction. His father is doing better. I've seen him in the sobriety court meetings. I'm thankful for that because, as indicated by Mr. George, perhaps they can be supports for each other. But I also note, according to the report, that his father would often drink with them at home after school or work, which is not encouraging. So hopefully they can both make that change. I think the recommendation is appropriate, but I'm just very alarmed. I think the positives for him are that he's taken it seriously. He has gone to meetings of his own volition and he is employed. But this is the third young person this morning with high blood alcohol and an accident and children. It's a very, very bad curve for this community to be seeing not only himself, but other individuals placed in danger once again from an accident at a very high rate of speed. So I struggle. I think the recommendation is appropriate for probation. He obviously needs the services and the support. The one thing I struggle with again is, I think the other two individuals this morning, we had an upfront jail recommendation, even if only for a day or two. And I think that gives a great perspective to someone. If they violate probation, they start drinking or they start using another substance in its stead, they're going to end up with some additional jail penalty. I like to utilize that as an additional wake-up call, if you will, at the start of a probation term. And I think that would be appropriate here as well. That as opposed to there being any deferred, that there be another day or two served on a weekend, obviously, so it doesn't interfere with his employment. But I think an additional sanction is needed when there was an accident of this nature. It's unfortunate that he went off the road, but also somewhat fortunate in that he didn't strike the utility vehicle and kill somebody in or around it or himself. So I just get very alarmed at these particular factual circumstances.
Well, they are an indication that you can't drive very far with a 0.19. This was in May 16th. And you can't drive very far when you're this drunk. The one guy was going to drive all the way to Sturgis. I mean, from Sturgis to Kalamazoo. I forgot, where were you doing your drinking?
I was drinking at home.
And then where were you going?
I went to Mendon, to the Johnny's there.
To get a can of beer and a vape?
Oh, yeah, I got a vape.
And then you were going to turn on and drive back?
Yeah, that was it.
Why'd you go all the way to Mendon?
The power was out. It was that night. It was the night of that big storm.
Oh, yeah,
in the middle
we
of the
talked
day.
about that,
And,
yes.
yeah, in Centerville, the Johnny's was out of power, so.
All right, what would you like to tell me?
This definitely has been a wake-up call. But honestly, I wish you were under better circumstances, but I'm glad this happened, because without this, I don't think I would have turned around the way I did. I've been sober for over 4 months now. I'm far more family oriented. There's nothing standing in the way of that now. No addiction or anything could possibly change my mind about how important my family is to me. I'm really grateful I can be there for them now. AA is a great support group. I expected to go in there and people kind of look at me funny, because of my age, thinking, hey, I've spilled more beer than you've drank in your lifetime. But they were very supportive and they were happy to see you.
How old are you?
I'm 23, Your Honor.
We have trouble getting through to 23-year-olds. You seem to get it. It's hard. Now, your dad, as Ms. Canfield said, he's sick and tired of being sick and tired. He's got lots of bumps on his head and he's got life experience, and I hope he's done with it. When you're 23, you don't have enough bumps on your head. Plus, it's fun. It's fun to go out with your friends, and it's fun but it isn't fun when it stops being fun. Each one of these cases, because the people were intoxicated, they made bad decisions. If you were a little bit drunk, it's like, boy, I probably shouldn't drive down there. When you're 2.5 times the limit, it's like, I can drive. I need a smoke. And this is what happens. There was a woman there. There was a woman that they never identified. Do you know who that person was?
On the scene?
Yes.
Yes, my sister-in-law. I believe she was going to try to come pick me up, but I stayed with my vehicle because I was ready to.
All right, so you called somebody to come get you?
I called my wife and she sent her sister.
I bet your wife was happy. Okay, so she wasn't in the car with you?
No, she arrived in her own vehicle to pick me up, but I stayed with my vehicle. I knew what I'd done and I was ready to accept responsibility. I knew at that moment that nothing was gonna stop me from doing it again if I didn't speak to the sheriff that came and picked me up. And
Come pick me up, I've landed. Yeah, all these were bad. This is 40 yards into a cornfield. And these all happened within the same month and all got set for sentence in the same day. And there are some estimates on how many drunk driving cases do not get arrested. They make it home. And manage not to hit anybody on the way. And the number's astronomical. There are also some studies about how many times people actually drove drunk before they actually got arrested for drunk driving. Those are frightening too. But there's literally hundreds and hundreds of other drunk drivers that don't get arrested. On any given night, there may be multiple people out. Throw marijuana in the mix and people are lawfully using marijuana. There's no indication of that here. But we've all got blasé about that too. You regularly and continually smoke marijuana and also drink, and that's like, Anyway, as I indicated, you had bad judgment because you were drunk. You're in the National Guard. You got that going for you. There's going to be a consequence. You've also got kids that you should be home with. And this is also going to be money away from your family. They left you in jail for a couple days before they bonded you out. So you did 2 days up front. You were polite and cooperative with the officers, but you were drunk. And we discovered who the mystery woman was. I'm going to follow Daniel's recommendation. If there is going to be any jail time, it'll be because you don't comply with the terms of the probation. I won't hang any more over your head, but I'm going to order 2 days, credit 2 days, 12-month probation, which could be discharged at the end of 6. You're going to go to the victim impact panel. I'm not going to order highway safety, substance abuse treatment, AA, no drugs and no alcohol, and test as directed, including no marijuana. I don't think marijuana is an issue.
can't do it in the reserves, Your Honor, so I have no problem with that.
Very good. Well, this is expensive. It was a $300 fine, $75 crime victims' rights fee, a $50 state minimum fee, $100 screening fee, $150 attorney fee, $480 probation oversight fee, police reimbursement of $255. And the victim impact panel is $32. But you will be able to keep your license. Do you drive vehicles in the military?
Oh, yes, Your Honor, I haven't offered to drive a vehicle since the
Well, this
incident.
would allow you to do that, but $300 plus $125 in state costs, $100 screening fee, $150 attorney fee, $480 probation oversight fee, $255 police reimbursement, plus $32. That's expensive, $1,442. If you complete the probation early, it could save you at least $240. I've got some hope here. I would be greatly impressed if you decide to be sick and tired of being sick and tired at 23. Instead of waiting 40 more years like your dad did. Again, as in all of our people, they're lucky they didn't kill somebody. These were all impaired, which I don't really have a big problem with. The impaired allows people to keep their license and get back and forth to work. The rules were different when I was young. I'd like you to take this form downstairs to the probation department. Any of the violations could result in additional jail time, but if you successfully do this probation, you could be discharged at the end of 6 months. Mr. Willis, 2 of my cases today were connected to parents I'd been working with. And as I told Ms. Parker, let's hope you can't pass this on to the next generation of your kids. So you go down to the probation department, they'll get you plugged in is what you need to do.
Thank you, Your Honor. Thank you, Your Honor.
All right, Ms. McKay. I talked to the sheriff at the fair. He had a booth, and he's the kind of sheriff that has a booth at the fair and will sit there and people will walk by and talk to him about things that are on their mind. But I just call him up if I had something on my mind. But anyway, he's doing a great job as our sheriff, and he's accessible and easy to talk to. He talked about how many fatal accidents we've had this year. Our law enforcement citation numbers are way up. Much more tickets have been written, much more tickets have been authorized by the prosecutor, a lot of drunk driving arrests. And in the first 6 months of the year, we had 14 fatal accidents through June. Last year altogether, we had 8. Between June and now, we've had about 8 more. So we probably had 20 fatal accidents so far, 20 deaths. Some accidents resulted in more than 1 death. And some of that's a factor of people driving around with very high blood alcohol levels. So let's change our theme here. This one does not have to do with alcohol and drinking and driving. It may have to do with alcohol, but it doesn't have to do with drinking and driving. This is domestic violence. It started as assault with a dangerous weapon and was reduced to domestic violence second offense. The defendant is Jeannie McKay. She's here with her lawyer, Mr. Paul Gibson. I'd hope to get some input from a complaining witness in this case. I let Miss McKay out at the time of her plea and set the matter for sentencing. She didn't get in any more trouble, apparently. I'd hope to hear a little bit about maybe mental health counseling and get some input from the complainant. Mr. Bates apparently doesn't want to talk to us or provide any additional information. Mr. Gibson, what would you like me to know?
It's my understanding that the defendant and the victim are no longer together, and that, you know, it sounds like it was a mutual relationship where there was domestic violence allegations, I guess, that she had made against him. In this incident, she herself was, I guess, suffered a laceration to her leg. Apparently, after she hit him, he pushed her to the ground, apparently. So this was a bad incident all the way around. The defendant went straight to jail. It's my understanding that she served 14 days. The victim is not interested, I guess, in getting forth any input. He didn't ask for any services. He asked that they not contact him. So I'm not exactly sure if, I'm thinking that if this court, if the 14-day jail sentence would not be enough of a penalty in this case, I would ask the court to consider probation. The defendant has a mental health history.
Actually, that's incorrect. I have a history of medical fraud. Yeah, big difference. Every time I tried to report crime, I ended up in the mental hospital.
Okay.
Not really my issue, but yeah, big problem, as a matter of fact. And so I've had issues with reporting crime since. There was no mutual relationship. This man had me trapped for 2 years. He lost me my jobs by stalking me outside my work. I was moving out of state when I ended up meeting him. And so, I mean, I feel like it's entrapment, generally speaking. I mean, and to be on probation in this state for another 2 years after I planned on moving years ago when he lost me my jobs, I couldn't get out of the state.
Do you plan to move now?
I would love to move. Yeah. I mean, I don't want to live somewhere
Well, where do you live now?
I'm on Sandy Drive right now.
With who?
I don't know what to do.
Well,
This
who
man
lives there?
He has destroyed it. It's an old friend, but he committed suicide or whatever. I don't even know.
The friend, so you're living, who owns your house?
It's Brad Swoveland.
Brad
Swoveland.
And he's deceased? All right, so you're in the house, but he's not there. Does anybody else live there?
Mm-mm.
Do you pay any rent?
Mm-mm.
They're probably gonna move to evict you. Well, Mr. Bates has got his own problems, and one of the problems had been methamphetamine. There's a pending bench warrant for his arrest right now, which may have to do with why he doesn't want to have anything to do with this.
I actually even contacted a DACES shelter or the, sexual abuse shelters and domestic shelters prior to this, like 6 months earlier, and they wouldn't let me in. They said I didn't qualify. So it's like, beknownst to me why I can qualify for a domestic assault charge when I couldn't get into a shelter when I needed the help. You know what I mean?
I guess I don't have an answer to that, but so what's your plan? You can't stay in this place not paying rent. Do you have relatives or friends in another state?
I was planning on just moving out of the state because if I get put in mental hospitals when I'm trying to report crime, I don't feel like it's a safe place for me.
Well, there was the earlier incident in Three Rivers. This is a DV second. There was an earlier one.
That was the Jim Littlefield.
Yes, so that was also, there's a mental health.
It was actually, no, there wasn't anything in Three Rivers.
I thought it was over on like 7th Street or something.
Now that man is out of his mind. He said he was going to sell me, and I obviously protested. And when I told him I wasn't crazy because they were trafficking girls, he kicked me out of the house because he feels guilty, I suppose.
Well, that's a good house to get out of. Ms. Canfield, any additional input?
I'm concerned about when I look at Mr. Bates's history, I see in addition to methamphetamine and multiple controlled substance convictions, a conviction for violence as well. I think that probably if she wants to leave the state, I don't know that probation would be helpful. If she's reporting that there's been violence and sexual assaults against her that haven't been dealt with, that's concerning. And it's not very often that we see it, but we do see what we call reactive abuse occurring towards a perpetrator who has been longstanding abusing someone where the victim finally reacts.
Yes.
I presume that may have been the case here, according to what Ms. McKay is saying. I think possibly a short jail term or credit for time already served would be appropriate, and no probation, and let her move out of the state to a place where she feels safe.
Those are my thoughts. I know Mr. Bates. He's bound over to circuit court on a methamphetamine charge right now. He's got a pending bench warrant in my court, and there's some assaultive history, and it's hard to tell what was what. They made a choice to take her to jail. She was there for 14 days. She got no real ties here, and she's living in a odd circumstance. When did Mr. Swovlin die?
Like last November?
So you've been in there since November without paying any rent?
No, I haven't been there that long, but I don't know.
All right, well, I'm gonna give you 14 days jail credit, 14 days. Zero fine, $125 in costs. And I'm gonna give you until November 15th to pay that. You're free to leave the state. There's nothing here for you but heartache. Do you have any income? Do you get disability or anything?
I was working, but he exhibited like stalking-like behavior outside of my work, and I got
Where
fired.
did you work?
At the Saginaw Golf Course. I was gonna work as the
Oh, yeah, you told me that.
grounds crew and bartender, and then I got fired for the police being involved.
All right, we'll give that to her. You're free to go do what you want.
Thank you.
But I would not recommend you have any contact with that gentleman.
Thank you.
But there's a mental health issue that underlies this, and I think unless you start to get some way to address that, you're gonna be right back in it. But I couldn't tell anything about drugs or alcohol regarding this. There's nothing in the report. They didn't show any blood alcohol on your booking sheet. I know that methamphetamine is the underlying theme with Mr. Bates. I don't know what we're dealing with, but 14 days, credit 14 days, you're free to go.
Thank you.
All right, that finishes our morning. We did all 5 sentences with 2 minutes to spare. Thank you, Ms. Canfield.
You're welcome, Ron. Thank you.
All right, that finishes our morning, which was a bit of some of everything. But I am concerned. The blood alcohol levels go up. There's marijuana in there. We had 3 near fatal accidents this morning. I don't know what the answer is. And the state legislature presumes that people will not get a jail sentence because that's a
The state of Ohio versus Kenneth Carney. Mr. Carney is before the court with his counsel, Mr. Moss, Ms. Nicholson on behalf of the state of Ohio. This is our final pretrial before the currently scheduled jury trial, October 20th, 2025. Ms. Nicholson, anything on behalf of the state?
Your Honor, the state's offer to Mr. Carney was to plead guilty to the aggravated trafficking with a minimum 2 to 3 year consecutive sentence.
All right, Mr. Moss, that the offer is rejected?
Yes, Your Honor.
All right. Okay, so anything else we need to do before the final pretrial? We've discussed the motion to limit is pending. The transport orders have been issued for your witnesses. That's all done. I know that there's an issue with regard to these phone calls, the motion to limit. I'll let it pend until it becomes ripe for decision at the time of trial.
The defendant did make the state an offer today that was rejected by the state. I don't know if the court wants that on the record.
If Mr. Moss, do you want that on the record?
It can't hurt, Your Honor.
Go ahead.
He offered to plead no contest to the F3 with an agreed sentence of 9 months with charges against Kalea Johnson dropped.
Okay, and that's rejected by the state.
Correct.
Okay. Do we have the issue with regard to civilian clothing locked up?
Yes. Okay. Arrangements are being made, Your Honor. Thank you for asking.
All right, then we will see everybody back here unless I hear from you before trial on October the 13th, right?
20th.
All right.
20th.
I'm sorry, I'm looking at the wrong one, October 20th, right? Okay.
Yes.
All right, thank you all.
I haven't seen him, but I can't. Yes, it's Scott Thomas. Yeah. What's he gonna say?
Do you have any other discussions with any other employees at Jamie's Attic?
No.
Did you ever hear your boyfriend, Mr. McEwen, discussing his tools with who?
Here tonight.
Do you have any other questions?
Did you see, were you there when Jamie's Attic told me that they weren't responsible for the sale of my tool?
Yeah.
Were you there when they said that my tools were sold, not stolen?
Yes.
Were you there when they also stated that the person that they sold my tools to was a regular at Jamie's Attic estate sale?
Yeah.
And were you there when they told me that they would have more estate sales coming up in that?
I'm going to object to this line of questioning and leading.
Repeat your question, sir. I'm going to sustain for now. Repeat your question.
So were you there when Jamie's Attic said that the person that they sold my tools to was a regular at their estate?
Nah, I'm going to overrule. Go ahead.
Yeah.
And were you there when they said that they would have some garage sales coming up or estate sales coming up in the next couple of weeks? And that they would get my tools back from me when they saw this person again?
Yes.
I'm sorry.
Did you overhear, did the employee of Jamie's disclose how much the tools had sold for? You did not have any discussion with any employee of Jamie's about that? Go ahead, Cross.
Just one question. Did you tell your boyfriend when you were back in the house that after the tools were stolen that you guys were gone too long?
No, I've never heard that statement. Sorry.
After your
You can step, do you have any other questions of her?
No.
You can step down. Call your next witness. All right, call your first witness.
Sure.
If I could, you know what? Why don't you do that? And while you're doing that, Fleet Flicks versus Flood. Did you guys give me a? Did you bring down here a dismissal order? Did I ask you to do that?
I did print it, Your Honor. I'm sorry. I didn't know you wanted it down there. I'll have Gina run it down right now.
Just real quick. Okay,
Okay.
so I'm recalling Fleet Flicks versus Flood, 2503184. You have the money, sir?
Yes, Your Honor. Before I do that, I'd like to state that I did go ahead and acknowledge that I did actually have my first paycheck. I started February 14th, Your Honor.
Okay.
So therefore, I was there over 90 days.
Well, how can I determine that? I mean,
I got the paycheck right here.
no, I believe you got your first paycheck in February, but I'm gonna have to come back. I'm sorry. I'm sorry. Have a seat. Come on, call your first witness.
Sure.
Thank you. All right, sir, your name?
Alexander Pachura.
Spell your last name, please.
You haven't had an assessment yet.
No.
Okay.
Apparently, it's either going to be Wednesday or Friday.
Of this week?
Not sure. I just know that the days that they apparently have them Wednesday.
Oh, are on Wednesdays and Fridays, but you don't know.
All I know is they put me on, the kite said that I was put on the wait list for it, so.
Okay. All right, so what would you like to do on this?
So I just asked to kick it out again. Our negotiations with the people kind of depend on Mr. Banda completing treatment.
Okay. And I think the reason that I set it to this date was because I didn't want it to go out too far with, looking at when's my, go ahead. 20th?
Yes.
No. Oh, I see why. Yeah, it goes out to that only because I am not here on the 6th. The 13th is a holiday.
Mm.
And then, so the next date is the 20th.
Well, Your Honor, I know if he's released, they'll send documentation.
Well, typically what will happen is they will send something to us indicating that he can be released or that he was released. So there's not much we can do by bringing him up and having the hearing. I
Right.
want him sitting there not knowing what was happening.
Right.
It sounds like the very fact he got that communication has put him on a track to kind of head that way. Okay.
Yeah, because that's the first step.
So I'll adjourn the matter to October 20th, 2025 at 1 p.m. Right?
Thank you.
Thank you, Bond. We'll continue. Thank you, Mr. Mayor.
Happens later, Mr. Banda.
Court does call the case People versus Maya Hines.
People. Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Hines. Ms. Hines, please state your name for the record.
Maya Hines.
Great, thank you.
We're asking to set this for final settlement conference, please.
Jury final settlement conference will be set for October 17th, 2025 at 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you. Bond continued with his conditions. Court does call the cases of the People versus, is it Judge Bond Sanders?
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Bond Sanders. State your name for the record, please, sir.
Deja Bond Sanders.
And I know there's been a probation review hearing. There's been a recommendation made by probation that was provided to us in the court. I know Ms. Pilara is not out here. Do you want me to read it into the record?
If you want to, go ahead.
I mean, I'm not used to her not being here.
Trust me, I know that.
So Mr. Bond Sanders' balance is $12.75. He has an arrears of $58. Her recommendation regarding the payment is to pay that $58 by the 30th, which he can do. And then he'll continue the payment plan, $58 per month. He did inform me today he has a couple job interviews lined up, one today and one this weekend as well. So looking for new work as well, which is good. He completed the DV program, reporting as directed, and I know the victim has been here a couple times requesting to lift the no contact order. And yeah, Mr. Hawthorne indicated that she was here in the hallway. If the court wants to hear from her.
I would need to hear from her because on both of these, both of his cases, there's a request to remove it. I don't know that I've heard from her before, but
She's got the baby. She can bring the baby in, right, Your Honor? Mr. Bonner says.
Ms. Barney, when have you ever known that I said somebody could not bring a baby into the court?
I was gonna say, He could bring she could bring the baby in, but
I like
fear
babies
court,
better
so
than adults. No, it's okay. Yeah, I understand babies better.
I don't want to act like I'm making rules around here.
I think I have.
No, you can sit right there and then I'll sit here and then she'll talk first.
Hello. I know I've heard from you before about what you want me to do.
Yes.
Okay. Oh, it's that one.
Till next month.
I didn't ask you. Was I talking to you? I was talking to the child's mom. All right. And you want me to lift the no contact provision, ma'am?
Yes, sir.
All right. How has it been going otherwise? Because I had
Good.
in terms of child exchange and everything.
Good.
Good. Okay. All right. Anything else you want to tell me?
Nope, that was it.
That's it? Okay,
Yes.
very good. Thank you.
Okay, thank you.
You guys can come back up. Sir, anything you want to tell me?
No.
All right. On the case ending in 0933, on that case, it looks like you're to continue your plan. On that case, I will grant the removal of the no contact provision. All right. And so I'll remove that. I will add a provision of no non-consent.
Inform my client if it need to charge his battery, so we certainly will get that done.
How often are you charging it?
Charge it go dead like every day and a half.
So I think when you get it, you're supposed to charge it an hour in the morning and an hour in the evening. So you don't wait till it goes dead. You gotta charge it every day.
That's right. That's what I do. I wait till it go dead to charge.
No, you can't.
He understands. He was saying what the issue was.
All right, so charge it every day, 1 hour in the morning, 1 hour in the afternoon. I'll give you one more shot. Come back again with all those violations and we could revoke your bond, okay?
Yes, ma'am.
All right, outstanding. Have a good day.
Thank you, Judge.
Have a good day.
Matthews.
Good to see. All right, let's see. So number 6 is Taekwon Evans, 25 PI 001278. Come on up.
Judge.
Boston. Free draw number Taekwon Evans, number 6. All right, second chance.
Your Honor, it looks like we just need a schedule for the work. We had some violations and we cleared them due to verifying some work. So we just need a schedule. Don't see where I've had an email from Mr. Evans.
You sent them. So you don't call, you got to email. Okay, I'm working. Here's my schedule. I'm like, okay. All right, appreciate it. Thank you, sir. Number 7, Ahmed Fields, 25 SC 001650. Ahmed Fields.
All right.
Says,
Subsequent notice, that's a bench warrant.
wait, hold on a second. It was just disposed of.
It wasn't.
This one. Yeah, it was like, it was a guilty plea.
Thank you, Judge.
Okay.
Didn't catch that.
Yeah.
All right, I didn't catch that either. I'm sorry.
All right, number 8, Keontae Hurd, 25 PI 000658. Keontae Hurd. Also an outstanding warrant from Mr. Hurd. Go ahead. What says the state?
Yes, Judge. Well, if he's not present, subject to good notice, that's bench warrant bond forfeiture, Your Honor.
Yeah. Let's see.
And I don't have any update for the court. I'm sorry, Your Honor.
Okay.
Eight, 9,
Yeah. 8 and 9, yeah.
18.
Oh, yeah, 8, 9, and 10. All right, number 11, I got Tony Hill, 25 PI 000707. Come on up, Michelle. You heard from Mr. Majeski? Oh, he's on the way. Okay, we'll come back to you. All right. Number 12, Jalen Hunter, 25 PI 001535. Number 12, pre-trial. Second chance.
No violations at this time, Your Honor.
Good to see you.
All right. All right, keep it up, Mr. Hunter. Okay, if you have any problems with it, reach out to Second Chance, okay? Thank you, sir. All right. Number 13, Conrad Jackson, 24 PI 009486. Here it comes. Pre-trial. Second chance.
No violations, Your Honor.
All right, Mr. Jackson, keep up the good work. If you have any problems, reach out to Second Chance. Thank you.
And Judge, since we are at that 6-month mark, no new arrests, no violations, is a removal of the monitor something we could consider today?
Yeah, I'm going to check with McBurney and see if they got that solid down.
Okay.
And I'll let you guys know.
Thank you, Judge.
All right, we got number 14, Keemon Jackson, 25 PI 000282. Keemon Jackson. What are you going to say, Bostic? Keemon Jackson. What says the state?
Thank you, Judge. State's request bond forfeiture bench warrant, Your Honor. Subject to good notice.
What do you got there of Second Chance for him? Anything?
Actually, we've not tracked him since June 12th, 2025.
6. All right, thank you. Number 15, Tamyon Johnson, 24 SC 006514. Good afternoon.
Hello, on behalf of Mr. Johnson, it's good.
All right. All right. Trial.
8/28/25, no new arrest.
All right. Second chance.
No, nothing, Your Honor.
All right. Thank you, Mr. Johnson. Thank you. Have a good day. Appreciate it. Keep it up. All right. Number 16, Fenty Cardbo, 25 PI 00254. Fenty Cardbo. What says the state?
Your Honor, state request bond forfeiture bench warrant, subject to notice.
What do we got there? Anything, Bostic, through that one?
Your Honor, we've not tracked him since July, if you're asking us.
Okay, not tracking.
Yeah, so that's it, yeah.
Sure. 24 hours.
Okay. All right. Number 17, Aiden King, 25 PI 000855. All right. Retrial.
Says 2/7/25.
All right. Second chance.
Nothing, Your Honor. No violations.
All right. Keep it up, Mr. King. If you have any problems, reach out to Second Chance, okay? Thank you, sir. Number 18, Young Lee, 24 PI 000489.
Good afternoon.
I'll acknowledge she's in here. She doesn't need a.
She's in bad shape. Judge.
Yeah, she can just stay seated. I see that she's here.
So I did call Andy from Second Chance. He says she's compliant.
Can I come see y'all, try to get this ankle monitor off of her or something?
Not with these charges.
Let's see, pre-trial, what do you got?
She was released, she was taken to Roulette for FGA 228.5, but she was released 7.5.
And second chance is good?
Yes, ma'am.
Okay.
We have to come back and see y'all. I mean, I'd love to, I'll come see you in Jordan anytime. That's.
Well, not right now, so we'll, I'll find out about her.
Yes.
She's got a co-defendant too.
Yeah, there was a whole bunch of cases out here. Some got dismissed.
Mm-hmm. Oh, okay. All right. Thank you.
Thank you.
All right.
Big excuse.
Yes, ma'am. Thank you. No, that was the shortest amount of time Ms. Rocco has ever been in front of me. Right. Number 19, 25 SC 0000973, Ravion Little. Ravion Little. There we go. Second chance.
Levette. It's Levette.
What?
Ravion Levette. It ain't little, it's Levette.
That was my note, Your Honor. I don't have a Ravion Little, but I do have a Ravion Levette.
Oh, it's down here is Little.
Okay, is that your middle name?
No, I don't know who little.
Hold on.
Yeah, damn.
Do you think that's your case? I see.
No, this is my case though.
Okay.
That just ain't my line there.
Oh, somebody's on the calendar wrong. All right. Anyway.
Gotcha.
Levette.
Levette.
What?
Go ahead, pretrial.
Yeah, no arrest, 215, 25. You got it, 215, 25.
What it is?
The date you got to leave.
Oh, yeah. Yeah.
All right. Second chance.
Your Honor, it looks like we've gone back and forth several times about an address. We sent some violations. There was a temporary address. And then moving again. I think really we just need an updated address and schedule. Says he's gonna send it, then we don't, and then we call him again.
What's happening, Mr. Levette?
There's my violations. Have
It's
been
your
there.
responsibility to make sure they have.
Is the address keeps changing, it's hard to get.
So it's the responsibility.
We need to make this a little bit more formal. How many violations have there been?
726, 82.
But I work too.
22, 823.
Yeah. They ain't never sent it to me.
No, you have to send it to them.
8914.
Kind of request.
I called on 920 to get it scheduled, didn't get it. Thought his grandmother was updating us, she wasn't.
No, this is a you problem, Mr. Levette, not grandma's problem. This is a you problem.
Where, can I speak to him briefly, Judge?
Yes. Let's see. You're gonna take, all right. All right, we'll go back to number 20. Let's see, Keon McCrary, 23 SC 190621. McCrary. There he is. All right. You can come on. All right.
He's had a couple of arrests since he was released from instance. They were new cases. Released 2/7/25. And there's 25 PI 00997. He's got a case Gordon. He was released in 7/8/23. There's a probation violation 7/18/25. There's Monroe 12/25. And he's got 2 other cases since then, a probation violation since this case.
All right. Second chance.
We have several dead batteries in the last 30 days, Your Honor. 823 to 94, 94 to 96, 97 to 99, 99 to 921.
Your Honor, the state requesting this defendant be placed in custody.
Your Honor, those probation violations was way before I had got locked up. And
I tell you what, why don't you have a seat over there in the jury box for us? I know Mr. Shaw, he's gonna want to talk to you. There's two cases here. All right, let's see. Number 22, Dontavius McCrary, 25 PI 000748. Dante McCrary. All right. Pre-trial. All right, anything?
Your Honor, we've actually been tracking Mr. McCrary. It's been dead.
How long? Since he got it?
March.
Fortunately, we have another request for, it has been tracking since you said March. Your Honor, that's another custody request from the state, Your Honor.
Have a seat over there, okay? In the jury box. All right. Paul Montan, 25 SC 002466. Paul Moten or Motan?
Yeah.
It says the state.
He might be in Clayton County. He meant.
Is he?
This guy right here.
Okay.
I was trying to see what's their inmate
If it'll come up.
his name doesn't come up, but it's he's arrested for those charges, 3 because you do fast.
We stopped tracking on 3/24/25 and it was in Clayton County Jail.
It's possible. You talking about position 23?
Uh-huh.
Yeah.
I mean, that is custom of the,
All right, we can look. And if not, you want a bench warrant?
yes, Judge. I mean, that'd be the appropriate matter just to say where his body is located. If he is in jail, then, that obviates the responsibility having for this hearing. So.
All right, number 24, Jalen Patterson, 24 SC 005522. Second chance.
He's good on our end.
Your Honor, my lawyer is on the way. He's coming from Augusta.
She just said you're doing good. You want to stay?
No, I'm good. I
Will you let Mr. Cruz know?
yes, ma'am.
All right, thank you, sir. All right, I've got number 25, Frederick Penamon. 25 PI 000232. Pre-trial.
25.
Second chance?
Oh, Your Honor, it just looks like we've had a couple of stops after work, had a conversation and can't make those stops. They were at addresses, not like needed places. And then there was a request by him on 2/16 to attend religious events. Did not have approval for religious events.
Yes, Your Honor. If he would be allowed to go to church with the ankle monitor, that would be what he's requesting.
You got to tell him.
Yes, ma'am. Yes, ma'am. I tried. They told me I couldn't go.
Oh, well, so you couldn't go. You couldn't go. I don't know. Is it near an address that you're supposed to stay away from? Or is it near an address where
It's nowhere near.
does the alleged victim go there?
I suspect that it's not in the bond order. Church is not an exception.
Let me see.
It's not an exception.
Oh, did you look at it? I'm trying to pull it up.
I think it's not.
Just got out in January?
Yes, ma'am.
You want to add that?
Judge, I'll leave that in the discretion of the court. Whether you want him to go to church or not, the state doesn't really care as long as he stays away.
Who else goes to,
case?
Is that where the alleged victim goes to church?
Ma'am?
Does the alleged victim attend services there?
No, I go to a totally different church. I don't know what church they go to.
All right. You want to just send me like an amended bond order?
That sounds great.
All right, thank you. Thank you, sir. All right, John Perrin, number 26, 25 SC 002766. John Perrin, there we go. All right, pre-trial. Second chance?
Your Honor, I think based on notes, maybe the defendant was in the hospital for quite some time. It was, the device was dead from 6/21 to 8/23. Then it died again on 8/24 to 8/25, then 9/3 to 9/4.
You been in the hospital that many times, sir?
Yes.
My goodness. All right. All right, well, you're doing good. Just let us know, okay? Well, I'll check with McBurney on that, okay? Thank you, sir.
Hour in the morning, just to be safe, okay? You're doing good. You take care, okay?
All right, number 27, Daquan Preble, 25 PI 000018. Right here. All right, second chance.
No violations, Your Honor.
All right, thanks, sir. Have any issues, reach out to the bonding company, okay?
Yes, ma'am.
Hopefully we'll get.
All right.
Thank you.
Let's see. We got Deshaun Royal. 25 PI 000334. So, we got anybody here from conflict office? Chief Robin? That's, who's your lawyer?
I had a lawyer, then I don't know if they dropped my lawyer or not, because I had just called up here and they said that I didn't have no lawyer. So I was trying to figure that out. And then
Did you have a public defender?
no, they said it was a conflict lawyer.
Okay, so, but it was free.
Yeah, they gave it to me when I was locked up.
Okay, so you need another lawyer.
Yes, I've been trying to request for that. I didn't know where I can call to go try to figure that out.
Where is he? Where do you think he needs to call? Over there? Yeah, I guess so. All right, we'll get somebody else to come over, okay? Because she'll be able to maybe tell you. So
Thank
how's
you.
that?
Thank you so much.
Okay, I'll get you back up in a second. All right, let's see. Wait a minute.
Yeah.
He's got two. Wait, is there one with you guys and one at conflict? Is there one, because number 29 is with you guys, right?
So. I think it's. Tanya, Roar, and she's not with us.
Okay, so we'll get back on that one. What about Kibiana Slayton? 25 SC 0059097. 25 SC 0059097. Kibiana Slayton.
Your Honor, subject to good notice, Your Honor states requesting bench warrant.
All right.
Forfeiture.
I could. You can maybe return it and make it of ours.
Okay, let's see. Number 31 is Kamori Strozier, 22 SC 180919. Kamori Strozier. It says the state.
Your Honor, thank you, Judge. Subject to good notice, that's a bond forfeiture, bench warrant.
All right, there's two cases there.
For both positions, 31, 32, Your Honor.
All right, let's see. Number 33, Ernest Stuckey, 24 PI 008065.
Here.
She coming? Okay. All right, row number 33, Ernest Stuckey.
Yeah, I'm just kick her a bird.
First, the first 100 days, 2 days. It doesn't show.
He's didn't show up. Second chance.
No violations for Mr. Stuckey. We just need him to contact the monitoring company and give a new address.
So reach out to Second Chance, give them a new address where you're living, okay?
Yes.
All right, thank you, sir. Have a good day.
Thank you. Okay.
Jemiah Sullivan.
I'm gonna have to come back.
So show what to go.
That's what we did this morning, Your Honor.
Oh, yeah, we did do it this morning. I'm sorry. Thank you. All right, I got Tavarius Thompson, number 35. Tavarius Thompson, 25 PI 000285. Tavarius Thompson. All right. Pre-trial. All right. Second chance.
We only had one dead battery on 9/15 to 9/20/21. But he was in Hateville earlier, like 1 o'clock.
I was at orientation.
Who did what?
Orientation.
Orientation for what?
FedEx.
Oh, but you didn't charge it? Did you sleep there?
Yeah.
So, but you still got to charge it even if you're at orientation.
I didn't know it was that.
Huh?
I didn't know it was that.
You didn't know that? You didn't know you had to charge it every day?
No, I do.
But you thought orientation was an
I
exception?
said I didn't know it was dead when I was at orientation.
But if you don't charge it twice a day, once in the morning, once in the evening, consider it dead.
I didn't know that.
Yeah, all right, charge it every day. I'll give you a second chance.
Thank you.
All right, thank you, sir. Let's see. Edith Walker.
He needs to be placed in custody so you can remind it. I'm taking this seriously at all.
Yeah. All right. Edith Walker, 25 PI 000269. Pre-trial. Second chance.
No violations, Your Honor.
Thank you, sir. If you have any problems, reach out to second chance. All right, number 37, Alicia Williams, 24 PI 009521.
I'm Carlos Gucci here for Ms. Williams of Judy Kim, who I work with, attorney record. Can I hold for announcement? I'd like to speak to Mr. Jenkins, which.
Where's the defendant?
Oh, okay, I didn't see her over there. Okay. All righty. All right, then we got number 38, Destin Wilson, 25 PI 000152. All right, pre-trial. Second chance.
Your Honor, we've not tracked since 7/16/2025.
Say it one more time.
Been dead since July 16th, 2025.
Be going to school. I'd be forgetting to charge it. I don't know if I charge it, I'd be sleep in my bed so far away from the thing it'll come on.
If we could have a moment, Judge, if we could.
Yeah, you can go over there and sit and y'all talk over there.
Yeah. Get over there. I do have a couple updated announcements. If you want those, just.
Sure.
With respect to Keontae Hurd, positions 8, 9, 10, I believe he's present in the courtroom.
Keontae Hurd. Come on up. All right, that's 25 PI 000658 and 25 PI 000659 and 25 PI 000660. Pre-trial. Second chance.
Your Honor, one, there's no incident address and no co-defendant info. We would like to have that so that we can track, because there's a stay away for that. There was no location from 8/10 to 9/14 on the defendant, meaning the device was dead during that time. And then it's not tracked since 9/15 at 11:42 PM.
Judge, Mr. Hurd indicates to me that essentially somebody went through his room, cleaned out his room, and threw his stuff away. So he just unfortunately did not have the charger. So it went dead at that point in time. And I'm just not familiar with the court's procedure in terms of who's responsible for providing the co-defendant information and location and things. But if that's on us, I'll happily attempt to cover that.
Right. I mean, I would get, this is just a guess. Ankle monitor's on him. He loses the charger. A month goes by. Have a seat over here in the jury box. All right. Did we get anything on Tony Hill? Number 11?
In that case,
Did I skip right over you?
then that is all.
Oh, okay. All right. Is your client here?
It is.
Is your client here?
He is, Judge, but, there was some complications potentially, and, we'll let you know.
All right, oh, you want to talk to Mr. Jenkins?
Well, no, the deputy said they had a warrant, and I got no idea what that's about, so as soon as I find out what that's about,
Is he in, they already take him in the back?
put him right there in this room here.
Okay, let's see. No.
Oh, yeah, outside of the, yeah, that's. Active benchmark, positive performing.
See one on here, but that doesn't,
Thank you, Judge. So can I hold my announcements? I'll find out.
Sure.
I do have, it's just sort of a unique circumstance, Judge, but his family is present, Mr. Sebron Powers. This is a situation where because of not charging, he was revoked August 4th. And then he was represented by Maxwell Shart at that time. Mr. Shart subsequently withdrew. Mr. Powers was supposed to come back before the court on September 8th, and then it got kicked down the line. The family just got a call from him that he is at Rice Street and not here today, and he's also not on the calendar. So essentially he's been sitting and.
So what's his first name?
Sebron. Oh, Powers.
Spells the. The last name? Okay.
And he got here and everybody said it was, he's getting on the outside door for today.
Yes, ma'am. Okay, we'll check on that, okay? All right, thank you.
It's not on calendar today though, right?
Yeah, it's not on either one of these. I'm gonna look in here and see.
Yeah, I'll be able. All right. So, what you want this morning, Bruce is on to how many?
There's 9 for the last 2 days.
9 batteries.
Yes, we
Let me grab that.
Oh, I thought you meant 5.
9 dead batteries.
Him to get into.
Right. So yeah, this guy's in Rice Street.
Which one?
Mhm.
All the violations.
That's the one said that it was on, the week I was out, and then it's supposed to be today. It's not.
Further than that on this. If you would go back, another additional 30 days.
So Mr. Sebron's mom, did he get arrested on something else?
His lawyer was late that day and his mom had been taught to have it be on the car.
I got you. All right, I'll let the litigation manager get him on a calendar. We'll get him on another calendar. What? Powers, Sebron, let me see, it's 20, I got 25 PI 000510. Yeah. He's got one in front of Dunaway too, but you'll see if you pull it up.
All right.
Yeah. He's supposed to be in front of Judge Dunaway on 14. Okay. So.
Watch out. We'll see if we can get him back in here sooner, but I'll talk with Judge Dunaway too. Thank you, ma'am. You want Dunaway's case number 2? Mr. Reynolds, you want Dunaway's case number? All right, it's a 24 SC 004345.
For the previous one.
You ready?
Yes, Judge.
All right,
Thank you, regarding Mr. Hill, so he's good to go.
number 11, 25 PI 000707. Now I knew I was needing Boston.
Position number.
Tony Hill. Well, let's see. Second chance. Number 11, Tony Hill.
Yes, Your Honor. So we, there's a couple of violations. We have an address for 288 Fairburn Road, Atlanta, but unfortunately, it seems to be frequenting a 404 Paynes Avenue and a 404 Whitehall Street for an extended period of time. Can't confirm or deny, but they're 6.5 miles from each other, so it's not a case of it's in my back door scenario.
All right.
Not sure what to do in there, I guess. I'm telling you.
So Judge, it turns out his lights got cut off at the primary residence. He says he sent an email saying he was going to a different residence. So I don't think it's a logistical problem, not a willful non-compliance. So that's what I got to say about that, Judge. It was just he went to different family members' houses.
Can you not let him know when you're going to stay at another family member's house?
He says he sent an email. And
Some communication, Your Honor, it's just frequent. It's not like, one time.
No judgment whatsoever. Has your power been off that long?
No, but it's a frequent problem at the house with my sister and her kids as well. And I have custody of my 12-year-old son. So sometimes I go to Paynes where someone can help me take him to school because I'm not able to drive.
Which leads me to my next request, Judge. Having said that, he's pretty much on lockdown. I did this bond hearing back. He does have custody of a minor child. You think we modify his bond order so he could take his child to and from school? Anybody have a problem with that?
Well, yes, Judge, in that this is a homicide by motor vehicle.
Yes. So he can't be driving. It probably shouldn't be.
Judge, he's telling me he's going to take Ubers to take his child to school.
If you want him to use an Uber? I don't know how we'll monitor that.
Obviously, our number one concern is him being behind the wheels of a driver. I don't have an objection to him getting his child to school as long as he's not behind the wheel of a car and he keeps Second Chance updated as to the address, the time, and his return.
You got that? So he has to use Uber, Lyft, or get his sister, ride with his sister, but you can't drive him.
Sure. If I write a amended bond order, Judge, can I say Uber, Lyft, or other commercial transportation?
Right. Yeah.
You understand that he doesn't drive?
Yeah, shoot it to me.
Thank you, Judge.
Okay, thank you.
Also, I promise I'll tell you, one of my buddies, lawyer in South Carolina, huge fan of yours.
Oh, yeah.
Yeah. I texted him, I was like, I'm in front of her right now. He said, please tell her I said hello.
Because he's got to know that obviously if he does use a private company, that there must be some form of receipt. He'd be able to prove that he used this company. So he's got to be able to do that.
So keep up with it. You got the app, just keep up with it and send it to Mr. Majeski in case the state asks for it.
Sure, Judge. I'm happy to do that. What I've done before is, I don't know, monthly good enough for you, Mr. Jenkins? Or you want to bi-weekly? Whatever. I'm not being sarcastic.
I know, John. Now that's not an issue. What is the ankle monitor? How do you guys carry?
What's the fact we don't track how their mode of transportation?
Bi-weekly, Judge.
Okay, just, put that in there bi-weekly.
All right, I'll just have them send it to me, and then anybody wants to contact me about it, we'll just go ahead and show it to them.
All right, sounds good.
Thank you, Judge. For that announcement, can we be excused?
Yes, sir. Have a good one.